The surface matter. Surface matter.
Leave it. Let surface matter. Criminal offering more than 14 years in Assam for value. Against the order of SAT, 2019, is it? Yes, criminal offense for that. Criminal offense. Yes,
The Lordship's permission may make a mention. Your Lordship, this is a matter wherein by your Lordship's order, we have got the possession of the property, wherein we were the successful auction, I am the successful auction purchaser. Thereafter, with an arbitrary use of power, the IDCO by suo motu has given a stay order, whereas DRT proceedings are pending, that you don't register the name in the auction purchaser. And it is also here that
the matter is pending before the DRT. Why have you approached here?
No, I have not. This is the bank which has filed this petition with a limited prayer to register the name since sale certificate and position
When
certificate.
you say writ court,
Yes, it is a writ petition filed by the bank. I am the successful auction purchaser, OP number 5 and 6. But because of not registering my property in my name, the divisional head IDCO Rourkela has given a stay order suo motu on a representation.
You just said that the matter is now also sub judice before the DRT.
Yes, Your Lordship.
So this relief which you are seeking for, can it not be granted in that
Your Lordship,
court?
I'll demonstrate how this has happened, wherein there is no stay order by the DRT.
File your name.
There is no stay order by the DRT.
All right.
But IDCO has given a stay.
Yes, next.
The service matter of
It will be taken up urgently.
Yes.
Obliged.
Beggar Lordship, pardon me, Lord. Item 35 of today's list, Lord. So the residential house has been sealed, Lord. The first day before rising, Your Lordship.
See that also. Yes.
Maybe pardon my Lord, item 34. Your Lord, counter has filed. I pray my Lord only 2 weeks time for filing rejoinder.
You want to file?
Rejoinder.
Item number?
34.
So Union of India is there.
My Lord, it is Union Bank.
Union Bank of India. Any interim order has been passed?
No, ma'am. No.
Right. The London Council for the petitioner submits that he has received the copy of the counter affidavit filed by the opposite party, and he seeks to file, intends to file rejoinder affidavit, and the matter may be taken up 2 weeks after. This matter. Yes.
Okay.
Rejoinder affidavit, if any, be filed in the meantime, so as in court and the London Council of the opposite party. Yes.
Supplementary list of judgments W152 of 2018.
the writ appeal is disposed of with certain observations.
I agree.
Item 2.
You have to file a reply, Lordship, item 2. That's all. Reply.
No, reply I have not filed. I have taken instructions.
You have taken to file a reply.
The grievances of the petitioner is auction purchaser.
No, Lordship, I can argue that then I
He
can
wants
that point.
he
Yeah,
wants
that-
forfeited money with interest. My Lord, the
No,
Supreme
there was
Court-
some indication that instruction
Supreme Court
if any
has
shall be
passed an
obtained.
order
What is
by
that?
taking the paragraph 34 and 35
The grievances of petitioner can be only ventilated before the DRT.
It can be, it could have been disposed on the date of first admission, Lordship. He undertook to
That is the
reply.
only.
Then if you render the judgment, Lordship, kindly grant me some time, I will respond to his, Lordship, relying upon his judgment.
Now, what was the instruction to be obtained?
Lordship, instruction, Lordship.
Millard, I have taken instruction, the money in question has been forfeited because within a stipulated time, the balance
Put it on
75%.
record, Mr. Sahu,
My
just what we want you to put it on record.
Millard, I will file.
File it,
Yes.
today's affidavit.
I will file it.
That's all we.
Yes.
We keep it next week, just file that.
Obliged.
That is how-
Obliged.
Because 2 dates you have stated that you will take instructions. So, that one, the Mr. Tuna Sahul and counsel appearing for the Indian Bank submits that instruction has already been obtained, but he intends to file an affidavit
Yes.
in respect of that, in respect of such instruction, and the matter may be taken up next week. Is this matter represented?
Obliged.
Grateful.
Item 3.
He, Lordship, in fact, as per my Lordship amendment, I have deposited more than 4 lakhs. Will they take a decision either to OTS or Lordship restructure can be also suffice?
On 14/5, also directed to approach the bank.
Yes.
He has deposited some amount, but he has not submitted any application for OTS or a repayment. Let him submit any application.
Lordship.
The Land Council, Mr. Swami, appearing for the UCO Bank submits that though the petitioner has approached the bank and deposited some amount, but he has not submitted any proposals for amicable settlement of the loan account, for the settlement of the loan account, and therefore, stop. Mr. Doyle and counsel appearing for the petitioner that he shall instruct the petitioner to do the needful in that respect, put up this matter. So let it come 2 weeks after in the meantime.
Can I fix it that I will say?
Am I?
No, for appearance before bank. I will appear and I will file a
Well,
proposal.
it is up to you, just appear and let this matter will be commencing from 21st of July 2021. The party shall apprise this court about the development, if any, made in the meantime.
Lordship.
Yes.
Item 4.
The bank approaches the mediation center. In India, we have also participated in mediation
In
process.
mediation, both the parties participated and it is fixed to future date for.
So it is,
Mediation process is going
is
on.
going on.
Yes.
When the date is fixed.
Next
date.
Yesterday date thila, future date କହିନାହାନ୍ତି.
All right. The land council for both the parties submit that the process of mediation is on and the matter will be taken up. And in fact, the date was fixed to yesterday and they do not know when the next date has been is posted for such purpose. And the matter will be taken up 2 weeks after, so that they will apprise this court about the development made in the before the mediator. Put up this matter.
Item 5.
It is for seeking direction against the magistrate to dispose of the application.
How these are under. No, from that will be with you. Yes, Mr. Panigrahi, what you say?
My lord, this is seeking direction to the magistrate to dispose of section 14 application.
14 up.
First time it is being listed.
First time this is this.
Take instruction about this start. You again, you have not given that number. It is pending before whom? District magistrate. Acha, we have already passed the order. You must have received that they should give the number. ଆପଣ ନଥିଲେ କି ସେଦିନ ଗୋଟେ ଜେନେରାଲ ଆସୁଛି ଯେ ଯୋଉ କେସ୍ ସିଜିଏମ୍ ଙ୍କ ପାଖରେ ଫାଇଲ ହଉଛି ସେ କେସ୍ ରେ ନମ୍ବର ଦଉଛନ୍ତି କେସ୍ ନମ୍ବର ଯୋଉଡାକ ଡିଷ୍ଟ୍ରିକ୍ଟ ମାଜିଷ୍ଟ୍ରେଟ ଙ୍କ ପାଖରେ ଫାଇଲ ହଉଛି ତା ଦେହରେ ନମ୍ବର ଦଉନାହାନ୍ତି କେସ୍ ନମ୍ବର there is a provision in the SI Act section 14 I think it is 1(9) that it is to be disposed of within a stipulated with that 60 days. So if you do not register the case on time, then that period they cannot invoke. They cannot come to this court that period has So it is, seems to have been deliberately done. You are just keeping the petition, not registering it, not giving any information to the person who is filing the petition, and keeping him in all darkness. That is the reason this matter
All
is
the
appeared.
petitions are coming because of that.
20.
See, in this case, annexure 1, if you see, seal is there, received 5/10/2002. After receiving, whether you registered or you have not registered, how the parties will know? They'll rush to the court only.
The case in which we passed the order, in that case, even the receipt also not there. So
17867 of 2025.
तो 5/10/2024 ରୁ ଆପଣ ଯଦି ଏ petition ଟା ଆପଣ receive କଲେ, whether it is not your duty to at least inform the party that what is the case number. ଆଉ ଡେଟ୍ ପୁଣି ପକେଇବ, ଆପଣ ଜାଣିଲେ ଯଦି ଯେ ମତେ 60 days ଭିତରେ ଗୋଟେ ଫାଇଲ ଓପନ କରିବେ, ତାକୁ ଏଇ ଡେଟ୍ ରେ ପଢିବେ କନସିଡରେସନ ପାଇଁ କି କଣ ଯାହା ବି ହଉ, ତ nothing is done. And so many petitions are being filed that
This court is unnecessary burden on this.
This order has been already passed and given the copy. We have given that that you have to come.
WPC 17867 of 2025.
17867. Who number ta कहले?
WPC 17867 of 25.
Every date time.
7/7/25.
That order should be the
7 July and posted to 21st July.
It will be sent
all the district magistrate.
in that case, we have directed all the, look, this petition has been filed by so-and-so for chief secretary to do the needful. All right, that is nine. For a direction of so-and-so, the land council for the petitioner submitted that even though the application was filed on 5/10/2024, it would be apparent from annexure P1, which is the petition filed before the district magistrate Cutter, but till date he is not aware either about the number of the petition or about the status of the case, and therefore necessary direction may be issued for expeditious disposal of these ones. A similar matter came before us on that is in so-and-so on 7, and we have passed the following order. In view of the state of affair, the matter may be brought to the notice of the Chief Secretary of the state to pass give necessary instruction to all the district magistrate to do the needful and register the case not only on the date of presentation of such petition, but also intimate the concerned party about the same and try to expedite the process and complete the same within the time stipulated in the provision under section so-and-so. Free copy of the order be handed over to the land council for the state for onward communication to the chief secretary, and put up this matter on 21st of July 2025. Land council for the state shall obtain the status of the petition filed by the petitioner on 5/10/2024 under annexure EY1 before the land and district magistrate cutoff. Yes.
And FRI this court the steps take.
And also apply this quote about the steps taken by the chief secretary in this respect. Yes.
Item 6.
6, 7, 8, 9 similar.
Same. Okay. एगुड़ा सब अन्य डिस्ट्रिक्ट मजिस्ट्रेट ना गोटे डिस्ट्रिक्ट ना होगा. You see the Cuttack, the Pune number नहीं.
District magistrate
same.
So
Cuttack,
Jagatsinghpur doesn't go to
Cuttack, Jagatsinghpur, Puri. You see this thing is
What might be happening is receive and dispatch section, they receive it. By the time they forward it to the district magistrate, it takes its own time.
Yes, next.
Item 10.
Similar matters have been also listed today. And similar matters that is so and so. And similar pair has been made, and those cases are pending before the district magistrate Jawasinpur, district magistrate Cuttack, district magistrate Puri. Hala, tapare seta lekhi. Yes, कौन पढ़ी नहीं?
Order number पढ़नी.
अच्छा, फिर order number तक, है ना? Yes. Next,
Item 11.
and that will be uploaded in the High Court website. Yes.
Item 11.
Here, the petitioner has challenged the seizure of his unit and proceeding to sell the same on mediation, negotiation, and ultimately by sale of the unit mortgage land by registered sale deed by the annexure 13 and 14. The fact of the case is like this. My lord, I have prepared a short date chart.
Who is the petitioner, Mr. Bagh? He had availed some loan.
No, he availed some loan to run a ice factory.
Okay, then what happened?
He did not pay,
Okay.
became defaulter. Then it was seized
Okay.
under section 29. In 2002,
Yeah.
thereafter, some negotiation was for one-time settlement, it failed. Then I approached this honorable court for sale of the land, but since they did not cooperate, it also failed. Thereafter, they issued notice for sale. And by negotiation, they decided to sell it to opposite power 3 and 4. And accordingly, they have executed registered sale deed. My plank of submission before and challenge is that a mortgage property of a guarantor or surety cannot be sold in exercise of power under section 29. That can only be done under section 31. That is my case. Your Lordship may kindly see, I have prepared the debt chart.
So the legal point which he is raising, so you are ready on that?
My lord, I'm ready on that. Only thing that, my lord, this properties, my lord, which has been sold so long back, my lord, and after that it has changed hands. Now it was sold to OP number 3 and 4. Now again it has been transferred hands, my lord. Now the question is this, my lord, section 29 and 31, whether OSFC can proceed under section 29 or not. 29 is my lord, it is a very special law, my lord.
What happened? Who is now the purchaser?
My lord, he was
OP number 3 and 4.
You are the present.
Yes, and OP number 3 is running a Aurobindo Sikhashram trust, and that's 3 students are staying there free and reading free there. And OP number 4 is sold to other persons already. And particularly, my lord.
Just a minute.
May I place the debt chart first?
Please read 29.
My lord. Where, subsection 1, where any industrial concern which is under liability to the financial corporation under an agreement makes any default in repayment of any loan or advance or any installment thereof, or in meeting its obligation in relation to any guarantee given by the corporation
or otherwise fails to comply with the terms of its agreement with the financial corporation, the financial corporation shall have the right to take over the management and possession of or both of the industrial concern, as well as the right to transfer by way of lease or sale and realize the property pledged, mortgaged, hypothecated, or assigned to the financial corporation. Then, 2. Any transfer of property made by the financial corporation in exercise of its power under subsection 1 shall vest in the transferee all rights in or to the property transferred as if the transfer had been made by the owner of the property. 3. The financial corporation shall have the same rights and powers with respect to goods manufactured and produced wholly or partly from goods forming part of the security held by it as it had with respect to the original goods. 4. Where any action has been taken against an industrial concern under the provisions of subsection 1, all costs, charges and expenses which in the opinion of the financial corporation have been properly incurred by it as incidental thereto shall be recoverable from the industrial concern, and the money which is received by it shall, in the absence of any contract to the contrary, be held by it in trust to be applied firstly in payment of such costs, charges and expenses, and secondly in discharge of the debt due to the financial corporation, and the residue of the money so received shall be paid to the person entitled thereto. 5. Where the financial corporation has taken any action against an industrial concern under the provisions of subsection 1, the financial corporation shall be deemed to be the owner of such concern for the purpose of suits by or against the corporation concern, and shall sue and be sued in the name of the concern.
Yes.
So my submission here is
You said that the other provision would be applicable.
31.
What did it say?
Where an industrial, may I place my note?
Yes, yes.
Where an industrial concern in breach of any agreement makes any default in repayment of any loan or advance or any installments thereof, or or in meeting its obligation in relation to any guarantee given by the corporation, or otherwise fails to comply with the transfer with the terms of its agreement with the financial corporation, or where the financial corporation requires an industrial concern to make immediate repayment of any loan or advance under section 30, and the industrial concern fails to make such payment, then without prejudice to the provisions of section 29 of this act and of section 69 of Transfer Property Act, any officer of the financial corporation generally or specifically authorized by the board in this behalf may apply to the district judge within the limits of whose jurisdiction the industrial concern carries on the whole or a substantial part of its business for one or more of the following reliefs, namely for an order for sale of the property pledged, mortgage, hypothecated, or assigned to the financial corporation as security for the loan or advance, AA, for enforcing the liability of any surety, B, for transferring the management of the industrial concern to the financial corporation, C, for an ad interim injunction restraining the industrial concern from transferring or removing its machinery or plant or equipment from the premises of the industrial concern without the permission of the board where such removal is apprehended. 2. An application under subsection 1 shall state the nature and extent of the liability of the industrial concern to the financial corporation, the ground on which it is made, and such other particulars as may be prescribed.
Yeah.
My
And
whole submission is
you say they have routed through the district judge by moving an application.
No.
They haven't
No,
done.
they have not moved the distinction.
But they haven't done. That's what your case.
Yes, no, my lord. My submission is, and this is the law laid down by the apex court as well as by the Hon'Ble court, that the property of the surety or guarantor cannot be sold under section 29. That only provision is 31. Your lordship may kindly see, I have the decisions on that.
Here, my lord, actually, my lord.
Let him complete that.
Yes.
Let him show the again.
I have 4 decisions, my lord. Besides
No,
the
no.
other decisions also.
The property which was placed to auction, it was the property, whose property it was?
It is the property of the Luni's mother.
So all industrial assets, my lord. There are lot 1 and lot
Let me
2.
complete.
ठीक है.
Mother. And during pendency of the proceeding, mother has expired.
Your mother was the guarantor or what?
Yes, guarantor. That I will tell, satisfy her from the record. From your record, from the record, I will satisfy you. First, let me satisfy your lordship about the law regarding sale of the guarantor's property. First, flag A, your lordship may kindly see.
Which paragraph?
I am taking note. Paragraph 20, your lordship may kindly first come to paragraph 20.
Section 29.
20. Section 20, 2008, volume 5, SCC
Yes.
176.
Section 29 of the nowhere states.
States that the corporation can proceed against the surety even if some property is their mortgage or hypothecated by it. The right of the financial corporation term of section 29 of the Act must be exercised only on a defaulting party. There cannot be any default as is envisaged in section 29 by a surety or a guarantor. The liabilities of a surety or guarantor to repay the loan of the financial debtor arises only when a default is made by the latter. Then 21, my lord. Paragraph
Latter
21.
means principal debtor.
Yes, my lord.
The borrower.
Paragraph 21. The word as well as, in our opinion, play a significant role. They confer 2 different rights, but such rights are to be enforced against the same person, that is the industrial concern. Submission of the land senior counsel that the second part of section 29, having not referred to industrial concern, any property pledged, mortgage, hypothecated, or assigned to the financial corporation can be sold, in our opinion, cannot be accepted. It is true that subsection 1 of section 29 speaks of guarantee, but such a guarantee is meant to be furnished by the corporation in favor of a third party for the benefit of the industrial concern. It does not speak about a surety or guarantee given in favor of the corporation for the benefit of the industrial concern. Then 22, my lord. The legislative object and intent becomes furthermore clear, as in terms of subsection 4 of section 29 of the Act, only when a property sold, the manner in which the sale proceeds is to be appropriated has categorically been provided therein. It is significant to notice that subsection 4 of section 29 of the Act, which lays down appropriation of the sale proceed, only refers to the industrial concern and not to surety or guarantor. Then, my lords, paragraph 24. My lord, your lordship may kindly turn to next page, that is page 189, second line. The rights and liabilities of a surety and the principal borrower are different and distinct. Again, page 189 from the top second line.
189, second line.
Again.
Oh, rights, liabilities.
The rights and liabilities of a surety and the principal borrower are different and distinct. Then 33, your lordship may kindly see. 33.
Hmm.
33 also towards the last third line, my lord. 3 lines. Section 3 also provides for a relief against a surety and not confined to industrial concern alone.
3 na sir, 31.
33, my lord.
33 ଅଛି ଆପଣ 3 ପଢିଲେ ନା it is 31 ଲେଖା ହେଇଛି.
Sorry.
Section 31 also provides.
ନା ସେଟା ମୁଁ skip କରିଯାଉଛି ଯେ ମୁଁ ପଢି ଦଉଛି ଆଜ୍ଞା ତାହେଲେ. Section 31 of the Act provides for relief which may be sought for by the corporation strictly in terms of thereof. Clause A of subsection 1 of section 31 of the Act provides for a final relief. It does not speak of any interlocutory order. Clause A as notice herein before has been inserted by Act 43 of 1985. Thus, prior thereto, even section 31 could not have been taken recourse to against surety. Such a relief, if prayed for, would also lead to grant a final relief and not an interlocutory one. Then 33. Similarly, clause B of subsection 1 of section 31 of the Act also provides for final relief. Only clause C of subsection 1 of section 31 of the Act empowers the district judge in the event of any application is filed by the corporation to pass an ad interim injunction. The very fact that section 31 uses the terminology without prejudice to the provisions of section 29 of the Act and or section 69 of the Transfer of Property Act, it clearly postulates an additional relief when can be done by invoking section 29 of the Act can entirely be done by invoking section 31 thereof also. But therefore, a different procedure has to be adopted. Section 31 also provides for a relief against a surety and not confined to industrial concern alone. Subsection 2 of section 31 also refers to industrial concern and not the surety. The legislative intent, therefore, to our mind, is clear and unambiguous. Then, your lordship may kindly see last, my lord, paragraph 47. For the reasons aforementioned, there is no merit in these appeals which are dismissed accordingly.
Now come to flag C.
Flag C.
Flag C.
My lord, I will take
Principle is same.
Principle is same. Flag B.
Flag C, the answer is there. Flag C, para 14. This is the answer.
Paragraph
14.
Ma'am, in view of the above, sale of properties by the guarantors and subsequent execution of deed of transfer and Annexure 5 are liable to be quashed for being done in flagrant violation of statutory provisions contained in section 31 of the SFC Act, which we direct accordingly. In such fact situation, opposite party number 2, the auction purchaser is entitled to get refund of the amount deposited by him with opposite party number 1 towards consideration money of the properties in question. Opposite party number 1, OSFC shall refund the said amount with interest at 9% per annum within a period of 8 weeks from today. Opposite party number OSFC is directed to recalculate the amount due from the money, including interest accrued thereon, and issue a fresh demand notice to be served upon the loanee as well as the petitioner guarantor within the time stipulated herein above. It is further directed as the opposite party number 1 OSFC proceeding illegally, it is not entitled to claim for legal expenses from the loanee petitioner guarantor. 1. On receipt of the recomputed demand from OSFC, the petitioner guarantor shall deposit the same within a period of 8 weeks from the date of receipt, failing which the OSFC shall be at liberty to proceed against the petitioner guarantor for making full recovery of the outstanding dues in accordance with law.
This is what would be their argument, to say that much water has flown under the bridge. Nothing could be done. This is the answer to their argument.
So now if this exercise is ultimately carried out,
Lord,
are you ready? They now calculate what would be...
Lord, yes, madam. And recent decision of our own High Court,
more than 1 crore.
Whatever.
Sir.
Let us see.
14 is the answer.
Well, that is the answer given.
Then
You
flag
have to-
D
you
or
have to
something
refund
like
the-
this and discharge.
You have to refund the money with interest, provided that. So that is why we want him that to assess it and let him file the affidavit, deposit the amount.
My lord, whatever he has submitted, my learned senior, it is not in the pleading, first of all. Secondly, my lord, section 29 deals with industrial assets, not with any
No,
other.
it
It is an industrial asset, my lord.
it is not the property of the guarantor.
No, my lord.
No.
Kindly see, my lord.
That's the entire argument here now is.
My lord, may see order dated 27/7/2003. Kindly see. 27/7/2003, order number 21. The matter is taken up through Mr. Bagh, learned counsel appearing for the
Order dated?
order dated 27/7/2003.
Yes.
23. Mr. Bagh, learned counsel appearing for the petitioner contended that land lot number 2 measuring 0.790 decimal of the unit of Las Glass Ice Factory and Cold Storage of Kalpodhara, Khurda is a pond and mortgaged property showing undue haste has been auctioned and sold on a very same day, that is 24/3/2008. It is further contended that as per the provisions contained in section 29 of the State Financial Corporation Act, the mortgage property being a pond cannot be auctioned or sold by the opposite parties. On perusal of records, it appears that nothing has been placed on record to indicate that the said property, that is lot number 2, is a pond and has been mortgaged.
That contention was different. Now he say that it is the property of the guarantor. They are the.
Here, my lord.
That I will show it on that one from
My lord, after this order, kindly see, therefore, learned counsel for the petitioner seeks time to produce relevant document to satisfy this court that lot number 2 is a mortgaged property.
Yes.
Then, my lord, order number 25, 1/8/2024.
Just a minute.
1/8/2024.
So just a minute. We are taking note of the first date you said. What is that date?
That date is, my lord, 27/7/2023.
Then
my lord,
1/8.
1/8/2024.
Yes.
Order number 25.
Yes.
By order dated 27/7/2023, the petitioner was given an opportunity to produce relevant documents to satisfy this court that lot number 2 of the disputed land is a pond and had been mortgaged in petitioner favor. The said order has not been complied with till date. Therefore, several adjournments were taken on one ground or other. We are prima facie satisfied that petitioner has not been able to make out a case as regards lot number 2. It is, however, petitioner case that Odisha State Financial Corporation has negotiated the sale price with one Kalpana Mahapatra at rupees 12,25,000. After auction notice, the petitioner land lot number 1 and the property thereon has been sold for 6.80, much less than the negotiated amount. Learned counsel appearing from the Odisha State Financial Corporation seeks adjournment to obtain instruction. We have filed our instruction how it is 12 lakhs. Now, my lord, the first question is that whether this property lot number 2 is a mortgage property or not. So, my lord, he has not been able to show that it is a mortgage property. Now, question is that lot number 1, my lord. Lot number 1, my lord, in lot number 1 includes, my lord, it includes the land and the building, my lord. Land and the building, my lord. That land and building, my lord, where the factory is there and the machineries. So it is in 3 counts, my lord, land, building and machineries. So, my lord, the land, my lord, we have filed an affidavit showing what is this lot number 1 and lot number 2. That affidavit, my lord, was filed on.
Is in the record, it is the mortgage deed dated 3/12/96, 31/3/92,000 is there on record. Mortgage deed. So that mortgage deed, everything is.
My lord, for that, my lord, that in spite of my
My lord,
repeated.
Where is the mortgage deed? Where is that mortgage deed?
My lord, may
Why,
pursue-
why to get into all these things? So was the mortgage deed.
I will show it, your lordship, from the record, my lord, that it is
So
mortgage.
that mortgage deed dated.
Not mortgage deed, my lord, it is deposit by
My
title
lord,
deed.
my
So
lord, kindly
no deed is
appreciate,
there.
my lord, kindly appreciate my
Let
affidavit
him
on
complete my
25,
No, come to page 18. Come to page 18 of your writ.
18 of
18 of writ petition.
writ petition.
18. The notice. See the notice. So was that
My lord,
18. That notice. Read that notice.
My lord.
2310 to 2002.
Yes, ma'am.
Read that.
This notice is the I.Sri Amay Kumar Naik,
Yes.
branch officer,
Yes.
for the do hereby order for taking over the possession of all assets of industrial concern of glass ice factory and storage, Sri Dilip Kumar Rai, having its place of business at Khawpoda, district Khordha, in exercise of
In exercise of the statutory power vested under section 29 of so-and-so act for breach of the terms and conditions mentioned in the loan agreement, hypothecation, deed, mortgage deed dated so-and-so,
Yes.
executed by the said industrial concern
In
in
favor-
favor of state financial corporation. So these two documents, everything is
my
clear.
lord, it is not a registered document, my lord. So
Whatever,
support is with them.
No, show that document, whether it is.
They have to produce the document, my lord, not I, because they are the custodian.
See.
They are the custodian, lord, you can see.
My lord,
Mortgage deed also, my lord.
See, the writ petitions are decided on the basis of the admitted documents.
My lord, right?
Disputed facts we are not going. So the
No.
admitted documents. See,
No, my
the
lord,
entire the entire dispute arises out of this notice.
No, my lord, your lordship may kindly see regarding mortgage, my lord. Annex page 19, your lordship may kindly see. Page 19. The seizure. Serial number 1. Land as mortgage to the corporation. Your lordship got it, my lord? Page 19.
Your mother might have signed that mortgage deed. Let us see that.
My mother was the owner of the land.
Oh, she might have signed the mortgage deed.
Yes.
Note that document.
But I told they are the custodian. I have
You,
filed a
why don't you
application.
produce?
They are
Bring
the
it.
custodian.
my lord, now
It is not a document.
The main
whose
document.
mother
My lord,
died.
let me complete then.
Mortgage property, my lord, this is an industrial concern, my lord. On this, my lord, the building.
Why
was-
don't you show that document? Let us
My
understand what is that document is
My
about.
lord, kindly see this document.
This document, my lordship.
Show that document.
Now see this document.
Better let me complete regarding the mortgage mal from the document.
Where is this
Then
buildings, my lord?
haphazardly it will not sufficient.
Entire case is based on the principle of natural justice. He has not challenged the auction notice, my lord. And the auction notice, this document shows, my lord, the petitioner as well as the mother is the owner of the property after death of his father. And my lordship, it is also astonished.
Have you taken such plea? There is nothing in, they are stating that there is nothing in the pleading.
That document is not in the.
In the year of 1999, my
That document
lordship.
is not in the counter affidavit.
No, my lordship, in the year of
Your
1999,
Readings are also not there.
my lordship,
My lord,
in the year of
The pleadings
1999.
are not there, Mr. Bagh. How can you argue the matter?
Now regarding that document which is produced from your
You are
lordship.
stating that you are making a submission that this particular property is a mortgage property.
Both the properties are mortgage property.
Yes, ଆପଣଙ୍କର averment ହିଁ ନାହିଁ ସେମାନେ କହୁଛନ୍ତି show us that from the averment.
My lord, may
I am
see,
showing the documents, my lord. I am showing the document that
my
it
lord,
is
may see
mortgage.
page 21 of my counter affidavit. This is the
Let me finish, then let them say.
Yes,
My lord, annexure 19 your lordship has seen. Land as mortgage to the corporation. Page 19, my lord. Then your lordship may kindly turn to annexure 3. The demand notice, bottom, my lord. Bottom. Copy forwarded for informational resurrection to Pramada Kumari Rai, the mortgager. She being the guarantor, oblique mortgager. Then, my lord, your lordship may kindly turn to page 43. Annexure A by 1. Their document. Your lordship may kindly to running page 43. Bottom, my lord. Copy communicated to Pramada Kumari Rai. Such and such. Then Your Lordship may kindly turn to Annexure C/1, page 45. Copy forwarded for all information necessary action to Sri Pramoda Kumari Rai, such and such, she being the guarantor of the mortgagor to the loan available by the such and such. So these are their admission. They have seized my mortgage property, and it is, your Lordship may kindly see, mortgage as per the Transfer of Property Act are of 6-7 types.
My lord,
And it is a mortgage by deposit of title deeds. It is not a registered document. Had it been registered, I could have obtained from certified copy from sub-register office. The mortgage deed is with them. They are not producing. Under the Right to Information Act, I applied. They said it is missing. They have replied it is missing.
My lordship, in the year of
all these things, my
1999,
lord, is
Your Lordship may call for the record, my lord.
My lord, the
At my
auction
call.
notice at page 21, my lord may see for the auction notice. Clearly, he was given an opportunity, and my lord, he is deviating from the main subject, my lord. The main subject is that we had offered him an OTS offer, my lord, asked him to pay 3 lakhs, my lord, out of 12 lakhs, but he failed, my lord. So when he failed, what was the recourse available to us? It is section 29, my lord. So we went for section 29, and thereafter it was seized. Page 21, my lord, showcases that how, my lord, we have given the sale notice. My lord, one minute. Page 21 for a moment, my lord, it is I/1 in my counter affidavit. Thereafter, this is the sale notice. My lord may have a glance.
Which one?
Page 21 of my counter affidavit. This is a sale notice, my lord. Where, my lord? This is lot number 1 and lot number 2. Now, my lord, he is changing his stand that now the property has been mortgaged. First, he told that.
No, he doesn't say that entire property is mortgaged. If that
Yes, my information, entire property is mortgage, my lord.
He says now entire, my lord,
Yes,
building,
that is
land,
right.
everything is mortgaged. So
No,
on the
that
section
was a
31, I have to go. And my lord,
Earlier, the CORAM which is passed, that is in respect of the
after that,
bank.
my lord may see the next page.
And your lordship
Now the
has
possession
seen
letter was handed
that
over.
there
He
is
never
no deed.
challenged all those things.
But in the, even in the amended writ petition, you have not said all this.
But this is purely
Not
possession
amendment
of
of the
the
writ petition.
There is no dispute that.
this was not challenged.
Never challenged.
And the sale was confirmed.
Again, ticket କହିଲେ କଣ ହବ? Let me complete
And my
first,
lordship,
then
he,
they may start.
committed a fraud, my lord. In the year of 1999, the petitioner and the mother has sold the mortgage property to third person, and they are of then and there the OSFC has also granted loan to the in the year of 1990 the cyclone loan.
It is completely false, man. Let them produce any comment, my.
My lord, kindly appreciate one thing.
They both have sold, my lord, the mortgage property.
My
That
lord,
is the
only who
document.
is a defaulter, we auctioned that property, possession was handed over, everything was done. Now he comes after 15 years, makes an amendment to the writ petition, challenge, my lord, already deed has been executed, my lord. My lord, deed has also been executed. After that, he challenges the deed in 2000, after 21, my lord. Now he says that all these things has to go back. And he's a defaulter. My lord, can he say that he's not a defaulter? He is a defaulter, acute defaulter.
And this mortgage property has been sold by the petitioner and the mother in the year of 1999, my lord, to third party.
My lord, the deed was executed. And one was executed at 7/8.
Let me complete better. Your lordship can understand.
2008, my lord, already it has been executed and registered.
All right. We are closing the argument. You file your.
So, my lord,
My lord, for a moment, my lord, let me complete, my lord. Let me
I'll
complete.
written note of file.
My lord, your lordship may kindly see on 24/3/2008, they took the decision to sell by negotiation. And immediately 4 days after, on 2 days thereafter, on 26/3/2008, they executed a sale deed in favor of OP number 3. But
my lordship, the petitioner has also petitioner sold, then and there I purchased.
Then my lord, I signed the writ petition.
Acute defaulter, he didn't have any respect for the
This is what we are arguing to analyze the magistrate court. Let me finish, my lord.
Mr. Bagh, learned senior advocate, Mr. Patnaik, learned counsel appearing for the OSFC, and
PK Knight for OP number 3
PK Knight for OP number 3
and 4.
and 4. Argument is closed, judgment is reserved. The parties are may file their written note of submission by 14th of July 2025. Yes.
I have already submitted.
May I
the
submit this
petition.
document to my lordship? May I submit this document?
Whatever you want to file, file by 14th. Yes, we are reserving the judgment. Yes.
You file the counter and everything. Now you are throwing papers on.
No, that's it. Yesterday I received him, Lord. That's the whole.
Next.
Item 12.
My decisions are there, my lord, only I filed the note.
You filed consolidated.
I will also file the document that sale is confirmed, that cannot be challenged without challenging the.
Yes,
option.
next.
Item 12.
May I please, your lordship? My lord, one amendment petition is pending in this case. My lord, may I please, your lordship? My lord, one amendment petition at flag L. I want to, certain developments have taken place during the pendency of this matter, my lord, which was filed in 2018. So those I want to bring on record. A decree passed in favor of the guarantor, which died in the meantime by the civil court, declaring the mortgage was bad. That I want to bring on record. That is enclosure D to my IA. Judgment that your lordship, my learned friend Mr. Bagh was placing, that judgment that is in any case I did not plead that also. That filing a fresh application will be difficult, my lord, because already pursuant to my lord's direction, I have already deposited 20 lakhs. Your lordship may look at page order number 6 dated 2/3/2023. May I submit, my lord? My lord, if your lord. My lord, I will rely only on 2 clauses. Your lordship may call it tomorrow, day after tomorrow. Of the amendment, I shall not come with the entire thing, or the next week, my lord. So that it looks big, which I can
On Monday.
2 paragraphs.
Not day after tomorrow or next week.
And any day the court see. Which one? Regentry. That is, there are several things. Yes, that I had offered. That is why your lordship directed me to pay 20 lakhs, which I deposited.
My lord,
Your lordship may take it on Monday. Your lordship may take it on Monday. I will brief it further.
Let me submit. You have completed, let me submit. The question of redemption at this stage doesn't arise at all, because the property has already been purchased by OSFC itself, since no bidder came forward to participate in the auction. So OSFC has purchased the property itself by paying. That is long back. And in the meantime, the petitioner has traveled from lower court up to the Honorable Supreme Court in different, everywhere his application has been discussed.
We are running our office there, Balusar office, and the entire premises is being used to store the seized vehicle as a garage. So that is being used.
Absolutely wrong.
That is being used.
I filed for.
Otherwise,
Anyway, that is something
apart
else.
from that. And your lordship, may I kindly draw your, he has made this amendment without any basis, because the property doesn't belong to the guarantor. There is no guarantor. We have already purchased. At this stage, it is not
My lord,
possible to.
court's order, your lordship's order for redemption. Those orders also have been closed. Redemption order have been passed by my lords. All these things are here.
The redemption, because law is very clear,
So, my lord, what I
right
am
to
telling
redeem,
is-
right to redeem extinguishes once the property is sold, my lord, as per the TP Act. And recently also the Honorable Supreme Court has held, under the Surface Act, of course, that once a sale notice is published, the right to redemption goes. So here, we have already purchased, because this is a closed matter, altogether closed matter. He is approaching your lordship in different writ application on different grounds for the same relief. And now, he has come with a fact which amounts to a total paradigm shift. Now, he is relying on that decision of Supreme Court, Karnataka, and our own High Court decision. That is, it is a guarantor's property, so it cannot be attached under Section 29 of that. But in this case, the property has been mortgaged by the principal borrower himself. There is no guarantor, because he got it on a lease and assigned the property to OSFC in order to establish the industry. And with the money of OSFC, building, machinery, everything was purchased and constructed. And he was given umpteen number of opportunities on several occasions to repay and failed.
How do you say what this amendment you are seeking for?
The lordship saying, sir, why I am objecting lordship suggestion?
But so many things are in that. Obviously, they also may file the objection to that. So let us say in spite of.
I will show two documents. Thereafter, lordship, I will oblige my lord to whatever your lordship says. Still, if your lordship feels that I need to file a fresh application, the interim order is here also. My lord, may kindly look at the first order your lordship has passed.
Now,
Sir.
You will now confine only
Two.
the entire, because other things are.
Yes. Maybe could be reputation or those are there in the rejoinder. I way of elaboration had given it.
We want next week so that it can be.
My lord, it will be better.
So many development is taking. You are bringing everything in piecemeal manner.
No.
Throw it and file a consolidation.
That is a very good suggestion. One or two paragraph, your lordship may consider that. I won't go beyond that. Nahi sir, mu curtail kar debi. Dekhibi tike, examine karibi. I will curtail that. That is.
But the suggestion will stand. After 2 weeks, you consider and tell us.
Paragraph of the portion the curtain
Sir, ଦେବେ ବୋତେ ମୁଁ ମନା କରୁନି sir.
No new development, only he
ମନା
has come
କରୁନି
up with
sir.
a fact.
ମୁଁ ମନା କରୁନି.
Now,
I
before
don't say ମୋତେ
that the property belongs to the guarantor.
next Monday. That is all.
So
Next Monday.
it couldn't have been attached under section 29. That is the new case.
Whether I will accept your lordship's suggestion or not.
And this thing he is raising for the first time.
I am saying this amount has been quantified by them itself. That is at page 36.
So that
17 lakh 79.
arrive.
Excuse me when I am arguing.
Yes. Mr. Sarangi, if you have already deposited the money as per the order of this court in this writ petition, that thing can be taken into account. If you file a phrase one, they cannot deny that no, in that writ petition it has never, that will be never the argument. So the
Sir, ମୋତେ ଟିକେ predict है.
अच्छा हाँ ठीक है जी ठीक है. We are giving you time.
Professionally ଟିକେ.
No ठीक है जी all right. कितने नंबर से जो आईए नंबर का फाइल को देंगे
सर एल
माने 3940 तो
3940 सर
IN number 3940 of 2025. There is an application for amendment of the writ petition. Though in the schedule of amendment, number of paragraphs have been mentioned, but Mr. Sarangi, learned senior advocate, appearing for the petitioner submits that he may be given some time so that the amendment can be court shut, and he also may take instruction. Will take instruction from the party concerned whether he will withdraw the writ petition seeking liberty to file a fresh one in view of the least pendants development.
Can it be called on 16th, my lord? 16th will be 16th.
No,
next week.
We are giving you on 21st week. We are giving you. You take that 21st.
Interim order was there.
Interim order not to alienate, we are not going to alienate because the property we are using it.
ନିଜ ବାଲେଶ୍ୱର ଅଫିସ କରିସାରିଲେଣି
କିଛି ତ ନାହିଁ ସାର୍ ମୁଁ ଫଟୋଗ୍ରାଫ
Photograph ଉଠେଇବା
ଆଜ୍ଞା ବହୁତ କଥା କହନ୍ତି କିଛି ନାହିଁ ସାର୍ ଫଟୋଗ୍ରାଫ ଦେଇଛି in any case interim order is there since last 7 years.
ଦି ଜଣ ଯାକ ଆପଣ ଯାଆନ୍ତୁ ଦେଖିବେ ବାଲେଶ୍ୱର ବୁଲିକିନା ଆସିବେ
ସେଟା ବି ସାର୍ ଫିକ୍ସ କରିଦିଅ
21/7/2025
interim order to continue
हाँ interim order.
Item 13. Item 13.
That
13. Like item 13, I am appearing for opposite party number 225 lakh. But when I see the last order here, though the son has been
Which for the petitioner?
I please your lordship. In this case, my lord,
No, which for the petitioner?
I am for the petitioner. I have filed a case before this honorable court in WPC 2262 of 2019, my lord.
Yes.
And that has already been disposed of by this honorable court in a division bench that is on 14/9/2020.
This is the writ petition which has come.
This is the after that the opposite party number 6 has filed an I that is I number 11
1110008.
No. That is 1497/2022. That is a petition filed by the opposite party that to recall, rehear, then set aside the order passed in WPC number so and so. And the same has been obtained by the petitioner of the above WPC by fraud and by misleading this honorable court. And in fact, that order has been recalled by the
Just a
honorable
minute.
court.
You are for the petitioner.
And for the petition.
Okay. As it appears by order dated 14/9/2020, we dispose of the writ petition.
Yes, by a division bench.
Yes, division bench. Now, who filed the application to recall that order?
Opposite party number 6.
Okay.
My relevant question before
What happened? Whether that order has been
that petition has been recalled. That order has been recalled by the division bench on 21/7/2022.
21/7/20. Just a minute.
Even though he appeared before.
Yeah, just a minute.
by filing Bhagalatnama in earlier
So
case.
also the order dated past is recalled. Okay, that has been recalled. Then, okay, then it is going on thereafter.
Then amendment has
Subsequently,
come.
amendment by the Honorable Court directed for amendment of cause title. I have already filed. But in fact,
That consolidated
Peti-
cost title is there.
yes, madam.
So
That is incomplete.
No,
That is incomplete cost title as filed and noting says.
No, noting says, but earlier that notice is not there. After order of this Honorable Court, today I have seen.
So it is only question of consolidated cost title, not the petition, any grounds that remains.
No.
Yes. So you are appearing for whom? There are 6 opposite parties.
So I am for 2 to 5 minutes.
2 to 5. So about 6 what has happened?
Lordship, I am appealing for.
Okay.
Lord, I have to file counter after that amendment.
Okay.
So let him serve a copy.
Amendment means what amendment? They have?
Amendment means let the subsequent management has carried out.
Only my lord typographical जोड़ा सेसु थिला TPC उड़े ले तो ना regarding only that.
It is the management that has changed.
Amendment के खाली cost title पर ये पूछती।
हाँ, cost title दा change.
Cost title पर already you got a cost title.
Cost title has already been amended and
consolidated cost title file is पुणी कौन जेटा order court order file इतिवो ना नहीं एमती file कर दिया।
after the order has been
objection कौन file करिए?
No objection. I have to file the counter in the repeats.
Counter कौन दापन कोई ले जे consolidated अपन।
Well, that is allowed. Amendment has allowed in last order.
So you have not filed the counter affidavit?
No.
What main matter is there?
Dispose of it, I recall it.
Main matter whether anything survives.
No, main matter has already been division.
Now it is recalled. Now it has
Yeah,
to be
now
recalled.
it has been recalled. My pertinent question before your lordship that what locus standa he has to file such type of complaint against me.
But that has already been recalled. We can't go into it.
Yes,
We challenge that order somewhere else.
He will file.
Now the writ petition is restored to its original position.
Yes.
Tell us what is the merit on the merit of the case. Why are you arguing those things?
Yes.
Is there anything survives in this writ petition or not? That is the question. It was disposed of on his application. It was recalled.
Yes.
That order has attained finality. You have not challenged. So then writ petition is restored now.
Yes.
Let us argue on writ petition as simple as that.
I am for the petition.
That's right. You argue on the writ petition now.
Yes, madam.
The order which you obtained, that has already been recalled.
Yes, madam.
Then
I will
don't make grievance against that order.
No, I am not grievance.
Somewhere else you have to make that grievance.
No, I am
not. Come to the writ petition.
Yes, madam.
What is the prayer and what survives? Tell us.
At this juncture, I pray I will file counter.
To the writ petition.
To the writ petition.
Yes.
Since that
the land council appearing for
2 to 5.
The opposite parties number 2 to 5 intends to file counter affidavit to the writ petition. What about opposite party number 6?
Lordship, if Lordship directs, there is no requirement.
No question of direction.
Lordship,
You have received the counter affidavit, whether it is necessary to file any counter, it is you are to decide.
It's challenging
We
to
cannot direct you to
Will you file or not?
Lordship, I will file. I will file.
The land council for the opposite party number 6 submits that the opposite, he will also file the counter affidavit. Put up this matter 2 weeks after the counter affidavit, if any, by the opposite parties number 2 to 5. So also by opposite party number 6 be filed in the meantime, serving copy on the land council for the petitioner. Yes, next.
Item 14.
Last order is also paying also.
4725.
4725.
Oh, this is the, yes. You were supposed to seek instruction.
Yes, my lord.
2000, whether
Yes,
OTS
my
of 2000, OTS scheme of 2011,
lord.
outstanding till 2019.
Try to, before coming to these systems, just submitting some heads, Lord.
No, tell us, the
Yes, Lord.
instruction you tell me about.
ଚାରି page ର order ଲେଖା ହେଲା ପରେ ଆଉ ପୁଣି କଣ ଆଉ?
No. My submission, I have not given any submission. I want to, some facts will be, your lordship, in the year of 1981.
You first answer this.
ଗୋଟେ order ପରା କରିଛୁ.
Yes, my lord.
The Land
Lordship's order, and this is.
The Land and Council for the OSFC shall not only obtain instruction regarding providing of opportunity of hearing to the petitioners
Yes, my lord.
while
Opportunity.
passing so and so, but also obtain instruction as to whether, as per the so and so, they are ready and willing to sentence. This was the specific order passed few days back.
Yes, my lord.
So what is your instruction?
Yes, my lord. That's the, my lordship.
You merely saying that opportunity of hearing has been provided to the petitioners will not do. You are to satisfy us by showing the document that you have issued notice, fixing the date, and that later also reached the petitioner. In spite of that, he did not appear. Then you pass the order. All these things, we have given the opportunity.
That's I'm saying, my lord, saying some facts and including this.
No, Chief, first you tell whether 2011
Yes, ma'am.
scheme you will consider their case or not. First question. Second question, if at all you are considering the outstanding as on 2019, on that basis you have to decide. These are the two things we have asked. Answer it as simple as that, we will dispose it up. We have heard it nothing less than 45 minutes that day.
No. I have not submitted anything. My lord senior has submitted. That's why I'm saying some facts, my lord. On the record, my lord, I'm not editing. My lordship, and the page 49, my lordship kind of will glance. And the
You are going again to the ଆମେ ଏଇ ଯୋଉ first time
Yes,
ଜାଣିବାକୁ ଚାହୁଁଛୁ.
yes, my lord, page 49, my lordship. Just after the order passed.
Have you really got the instruction or not?
Yes, my lord.
What is the
Page
instruction?
49.
So the instruction.
Shows the instruction.
Just the 49.
After this order, have you got
this order? Have you communicated this order to your
No,
clients?
that's yesterday, and that a telephonic message has come, and no written.
No. Then you
Because I have
obtain the written instruction. We want to know that.
No,
We pass the judicial order. No, you should have sought for time that we have not received any instruction. We have got the telephonic message. That will not do.
Yes, sir.
We just want, we have passed a.
Yes,
an
sir,
order.
I'll file the written.
File the
Yes,
written
yes.
instruction. We want to.
Yes.
Let us be clear on that.
Yes.
Let the managing director be file affidavit in this regard. Compliance of the order.
The Land and Council for the Land Council for the opposite party number 1 and 2 submits that he has not yet obtained instruction as per the order dated 4/7/2025. Let the managing director of the OSFC file an affidavit in respect of with regard to the instruction which has been sought for in the aforesaid order. Put up this matter. We'll fix it next week, or you want more time?
Kindly, I'll make a submission on it.
Yeah.
Every time the matter has been heard and the court puts a question, it is adjourned.
No.
We are taking it to a logical conclusion.
Please tell us, both of you, please tell us a date.
So next week, nothing else.
ଆପଣଙ୍କର ଦି ଜଣଙ୍କର କନଭିନିଏନ୍ସ ଯେବେ ହଉଛି କୁହନ୍ତୁ.
Next week,
next week,
Wednesday.
We commence in 14th. Because the MD,
14th or next
my
week,
lordship, if the affidavit will be filed, any officer, no issue. But if the MD, and whether MD is available or not, I have to take instruction. That's why I'm taking forward next week.
We are taking
7 days after.
We are taking it on the 18th.
Monday.
18th.
This is 18th of July 2025.
Yes.
And you give a copy of the affidavit in advance to the.
Yes.
Copy of the affidavit. Yes.
Item 15.
Yes, Item 15, as per direction of this court, the petitioner filed affidavit, received the yesterday.
And for the petitioner.
I want to give reply any day next week.
Just let us see the previous order.
Yes. That's your lordship will
Sometime
legal.
a submission was made to the council appearing to the petition of taking possession of the provision set up industry. The industry has started functioning and found opposite party opposed to such submission and submitting their mail start of the court of proceedings, and therefore there is no question of starting a business in the format. There's a competing claim, position on the parties and so let an affidavit to the photograph.
With photographs.
Well, I want to give reply of the same.
He has filed an affidavit.
With photographs.
With the photograph.
Your lordship will
Actually, upon dispute.
dispute କରୁଛେ status quo order pass ହେଇଥିଲା 2019 ରେ ଏକ mutation order court ଯାହା ଫାଇଲ କରିଛନ୍ତି of the year 2020 and photograph
May I just
status quo.
See, if you want to dispute the photograph, you have to give counter photographs.
And I will give the order of the DRT, and he has filed application for vacation of stay petition. And during pendency of that vacation stay petition, they filed it.
You only can say that these photographs are not from that place, somewhere else. That is the only answer you could
No,
give.
not necessary. But they are
Mr. Acharya, you have already filed the data.
it a say case just to recollect
We
that section 14 ଉପରେ 3 ଥର writ petition file କରିକି dismiss withdraw
and give reply. Yeah,
Say,
my friend has some.
Just a minute, Mr. Acharya and counsel appearing for this one also. And Mr. Patnaik and counsel appearing for the opposite party number 2 and 3.
Yes,
No?
sir.
2 and
bank.
And Mr. Saraswati and counsel appearing for the
Open number 1.
opposite party number 1. As for the order dated so and so, the land counsel for the petitioner has filed an affidavit with some photographs. And the same has been handed over to the land counsel. Copy of the same has been handed over to the land counsel for the opposite party. And both the parties submit that they may be given some time to have their say by way of an affidavit or photographs. Put up this matter on Kiberakia.
next
17 minutes.
17 minutes can it be
17 ହେଇପାରିବ ନା ଆପଣ ମଙ୍ଗଳବାର ଆଉ ଗୁରୁବାରଟାକୁ ଛାଡି ଦେଇକି ନା ଆଉ ଯୋଉ
18 minutes.
18 minutes there's some difficulty I'm not there
Put the
sorry
approval.
ସେ ମ୍ୟାଟରଟା ରଖାଗଲା ମୋର ବୁଢା ରଖିଦେଲ ତାପର ୱିକରେ କହିଲେ
22 ତାରିଖ
1 ତାରିଖ ହେଇପାରିବ 1st August
okay so let it be on 28th then.
It is regarding section 14 benefit will be given.
No,
Entitled to benefit or not, because it is not a bona fide litigation.
No, probably section 14, also section 5 also.
Anyway,
I will
section
give reply. Well, my friend
28,
has
7, 20,
benefit of
25. All right. Yes,
my
next.
lord ଖାଲି ଗୋଟେ request 28 ରେ there is some matter
ଅଛି
outstation
ଆଚ୍ଛା ତାହେଲେ କହୁନାହାନ୍ତି
29
ନାଇଁ ନାଇଁ ପରା କହିଲୁ
ଆଜ୍ଞା 30
ମଙ୍ଗଳବାର
30
ହଁ 30 right
30
make it 30th 30th of July
so
yes.
interim order to that
Interim order for that. Yes.
Item
Okay.
16.
My lord, item 16, just a minute. My lord,
judgment.
You can
yes, just a minute.
also
My lord, we are the petitioner, Union of the petitioner in this case. In a connecting case, my lord has passed the order against us. I just examine the judgment. Let's make it to debtor to
Let's harvest it.
next week any day. Accordingly, I just convey the CP.
final
Or
judgment
then
is
I
16
have no
July.
case, then I Lakshmi
Mr. Pari, the judgment has been handed over to you yesterday. The Land and Council submitted.
But to yesterday I have absent. I could not see gone through it.
All right. So we want it to be taken
Next
up
week any day, it's
Friday.
Friday. Yes, no, yes.
judgment ଏତେ ବେଶୀ ନୁହେଁ ତ
ଯଦି it is covered, then I am nothing to say.
RB number 132, 2006 retrospectively
Maybe, but
decided by the Honorable High Court of Allahabad, my lord, delivered the judgment on 2nd July.
The Land and Council for the opposite party, Mr. Rautrai, submits that in similar matters, a judgment has been pronounced by this court in WPC number
211713 of 2024.
by the order dated so and so.
That
And
email कर दीजिए.
covers issues involved in this case, and the copy of the judgment has already been handed over to the Land and Council for the Union of India. Mr. Pari, Land Deputy Solicitor General, submits that he wants to examine the judgment, and the matter may be taken up next week. Put up this matter on 14th of July 2025. कहाँ ना लिखा वो Mr.
Mr. Guchai, Deepak Guchai.
कुछ है बना. All right.
Item 17.
Item 17, my lord, Mr. S.Mishra is appealing for a P6, my lord. But today he is not well, my lord. And
Lordship, OP number 6 was directed to file counter by order dated 1912, Your Lordship.
The council is not waived. So
Not sure. I'm just saying that they might file counter and date because
the learned counsel appearing for no, a mention is made on behalf of Mr. S.S. Tripathi.
SS, my lord, on behalf of S.Mishra.
Acha, kaha behalf re mention korchen. Who is not well? Shivashis Mishra. A mention is made on behalf of Mr. Shivashis Mishra, the learned counsel appearing for the opposite party number 6. That is not waived and is supposed to file the counter affidavit and the matter may be taken off next week or a week after. A week after. This matter and you will come and see.
My lord, the petitioner filed a rejoinder to the counter affidavit filed by the state. Copy of the rejoinder.
Just a minute. This matter in the week commencing from 21st of July 2025. Huh?
55th.
Acha, 25th. The learned counsel for the state submits that rejoinder affidavit has been filed by the learned counsel for the petitioner, but the copy has not been served. Let the learned counsel for the petitioner serve the copy of the rejoinder affidavit in the meantime. Right?
Rejoinder affidavit to the counter affidavit of the state.
As a rejoinder affidavit to the counter affidavit filed by the state court. Yeah. So this will be on 25th of July 2020. We are just coming within 2 minutes.
Item 18.
Senior counsel Mr. S.A. Patnaik, will my lord, I am permitted to place this application. Lordship, the petitioner filed an application for vacation of interim order. I also filed objection to the same. That has not been recorded.
Vacation of the interim order.
Interim order passed by my lord's matter.
No, why will not hear the matter on merit? Why?
My lord, merit, but I am only bringing my lord to that.
Let us concentrate in the writ petition.
Yes, ma'am. Yes, ma'am.
Because counter has already been filed.
Filed.
So unnecessarily why you waste time? Once interim order has already been passed, let us finally adjudicate the matter.
The lordship will issue notice by order number 3, my lord. Dated 18/12/2024 has recorded the entire facts.
Just come to that.
Yes, ma'am.
Come to that order number 3 you are telling. 18/12/2024.
I am pressing. This writ petition has been filed by the petitioners challenging the order dated 25/4/24 of the London Central Administrative Tribunal, Cuttack in Oven number so and so. So the order dated 9/7/24 passed in the area review application number so and so. It appears that the opposite party Srimati Sanjeevani Raha filed OA 20/20/2020 before the London Central Administrative Tribunal, Cuttack challenging the actions of the petition and accepting her VRS in spite of withdrawal of the applications in the time limit prescribing the BSNL voluntary retirement scheme 2019. With a further prayer to pass the order dated 2/1/2020 and 31/2/2020 and to allow the opposite party to be reinstated in the former post and continue until superannuation. On Central Administrative Tribunal, Cuttack, after taking note of the contention raised by the Land Council for the respective party and clause 7 of the BSNL VRS scheme 2019, has been pleased to hold that the actions of the petition not considering the option of the representation for withdrawal of her VRS as illegal and bad in law, and accordingly passed the order dated 2/1/2020 and 31/2/2020 with a further direction to the petitioner to consider the case with the opposite party for reinstatement in accordance with the rules and formalities and to pass consequential orders. Mr. S.K. Patnaik and Senior Advocate draws the attention of this court to paragraph 9 of the writ petition, wherein it is mentioned that the opposite party accepted the benefits under VRS such as ex gratia of rupees 23 lakhs and terminal leave encashment of 4,18,915 rupees, and she also received the pension from the control of communication accounts with effect from 29/2/2020 and GPA from CCA on 2/3/2020. And counsel for the opposite party, on the other hand, disputed the arguments taken in the para 9 of the writ petition.
Notice was issued thereafter.
Yes. Now my lord, humble submission is, now the core question is, as per the scheme, my lord, the scheme was valid for a certain period. As per the scheme, once a candidate who was offered his VRS to obtain his VRS, and he has a right to withdraw the same before the closing date. And here is the case: the very person who has offered his VRS application first on 8/11/19, my lord, and again withdraw the same day. Thereafter, again he has applied, and as per this scheme, my lord, once a candidate
Again he has applied for what?
VRS.
Okay.
प्रथमे अप्लाई कले उड्रॉ कर देले, फिर अप्लाई कले, फिर उड्रॉ कले, accept system accept कलानी for second acceptance. Thereafter he filed hard copy on 25/12/2009. My humble submission.
That hard copy was filed beyond the time.
Beyond this. My humble contention before my lord is whether a person can opt for VRS and again withdraw the same more than once or not. That is
so the scheme.
That is scheme, my lord.
Can I see it again?
My lord, scheme page starts from page, my lord, 20, my lord.
Counter affidavit ତାଙ୍କର ଦେଇଛନ୍ତି.
Writ petition ଅଛି, my lord, Annex 1. It starts from page 17.
Page 24 lordship can take it.
1 minute. Let him come.
Yes.
Please come.
बहुत व्यस्त हूँ. The lordship can see the page 17, para 2. The scheme was valid from 4/11/19 up to 3/12/2019, my lord.
Para 2.
Page 17, para 2. The option for seeking voluntary retirement under the scheme shall remain open from 4/11/2019 up to 3/12/2019, 5:30 p.m. The effective date of voluntary retirement under the scheme will be 31/1/2020.
Yes.
Lordship, can the specific clause, I am bringing to my lord notice that one effort say cannot be permitted to withdraw the same second.
Yes.
That is available at page 24, para 7. Para 7 procedure. Last paragraph, page 24.
Yes.
Para 20?
And page
Page
24,
24.
para 7, that is procedure prescribed by the
Just a minute.
VRS.
Page 20.
I eligible employee.
Wait.
24 last.
24 last.
Repeat, man.
7. Yes. Yes. Ready.
Eligible employees shall be required to submit option to voluntary retire from service under the scheme during the period prescribed and as per the provisions of the scheme. Next question. 2. The VRS option of employees facing departmental judicial proceedings shall be accepted and only encashment, transfer grant, so and so will be released provisionally as per the Rule 69 of the CCCC rules, provided that the payment of excrescia and gratuity shall be released only on this one.
This is not applicable. This is not applicable.
Not applicable.
No.
The vital is clause 3, my lord.
Yeah.
The option once exercised under this scheme shall be final and decision of the competent authority shall be binding on the concerned employees, provided that the employees will be allowed to withdraw the option only once at any time till the closing time and the date of option. Provided further that the request for withdrawal of option shall be submitted online along with the signed copy of the right. My
Only one
contention before that, once he has submitted on 8/11, that is 8/11/19, he has withdrawn the same day after few hours.
8/11
2019
2019 प्रथम देले VRS.
से दिन संगे संगे 2-3 घंटा बाद withdraw कर दिला था.
Okay, same day withdrawal. Then next.
Then again on 86 same day, and exercise option to return on VRS. Say 8 again.
second withdrawal,
Which
was not accepted
by the system, has not accepted
system. And hard copies supplied
25/11, my lord.
25/11/2019.
19.
That time it was effective.
Yes.
The scheme was effective.
Effective, my lord.
Scheme was effective till 3/12/2019.
That is there is no dispute regarding that. And subsequently, my lord, considering that because the system will not accept all the various application has to be submitted on the online system. Online has fitted that they can withdraw once, not twice. That's why he has again submitted the hard copy on 25/11. My humble contention is that is one aspect. Another aspect is that even he has received the entire VRS due and even part of pension amount from the authorities. Having done so, at this stage, if that is when the scheme will frustrated. And my one brought
You can't set the clock back once again.
Once I have brought a judgment of the honorable court by Supreme Court, once we will accepted, this cannot be put on.
Let us see the reasoning of the reasoning of the court. Reasoning of the
reasoning either can see the page 767, madam. 67. The impugn order. Impugn order of the passage on tribunal. 67. Okay.
Yes.
A quoted the court tribunal has quoted at para 7.
No, you should read it. Para 9.
Para 9. Para 7.
Yes.
That is the once exercise at any time.
Para 9.
Para 9.
66.
66.
Yes. The applicant had applied for VRS. Para 9 of the impugn order, page 66.
Man, the applicant had applied for VRS on 8/12/2019.
No, that is 8/11.
Yes.
Yes, sir.
Correction.
8/12. That is the mistake.
Yes,
that has been corrected. Yes. Next.
8/11. Man. Withdraw it on same day, and then again I reapplied for VRS.
That also same day.
Same day. All these said actions were done well before the stipulated closing date of the scheme. As per the scheme, request for withdrawal of options shall be submitted online along with signed copy in the writing, which the applicant had once had done so. It is seen from the records that the applicant had not submitted the hard copy of the option for withdrawal of the same scheme, which is mandated as per the scheme. Therefore, the first withdrawal is no withdrawal as per the scheme, and the second withdrawal which was submitted
hard copy dabo boli kodi achi
again
hard copy dabo boli achi
under the scheme itself.
Scheme achi madam.
ଆପଣ ଦେଖିଲେ ପରା ଅନଲାଇନ ହବ ଏଗୁଡା
ଅନଲାଇନ ହେବ ତା ଦେହରେ ରାଇଟିଂ ସାଇନ୍ କରିକି ସବମିଟ
ହାର୍ଡ କପି ଦେବାକୁ
ହାର୍ଡ କପି
ପଡିବ।
ଦେବ।
କୋଉଠି ଆଉ ଟିକେ ଦେଖି ଦିଅନ୍ତୁ ସେଟା
Page 25 Maila.
Page 25.
Last sufferer of clause 3.
କୋଉଟା
Last sufferer of clause 3 Romanic 3 Maila. Provided that the request for withdrawal or option shall be submitted online along with signed copy in writing.
That's the reason the tribunal says that the first withdrawal is no withdrawal, because it is not completed the entire process. So the second withdrawal which you say is the right withdrawal, and it is accepted. Yeah, 25 bro. Yes, 25 which clause that is?
These are last sufferer.
Second provision.
Second provided. Yes.
এটা কাটি যেটা
Okay. Hard copy দিলে ही complete हो procedure.
Okay.
So in the light of these facts, read 9 you are reading. 9, half of the 9 you have already read. Read the rest of the. It is seen from the record that the applicant had not submitted the hard copy of the option of withdrawal of the scheme. Read it, and which is mandated as per the scheme. Therefore, the first withdrawal is no withdrawal as per the scheme, and the second withdrawal, and which was submitted on a hard copy, is to be treated. 67 at the top.
Further, it is seen from the scheme that just submission of option or withdrawal from VRS is not final as per clause 8(7). The competent authority had the final say on whether to accept or reject it. Therefore, when there is no withdrawal option submitted through hard copy, which is mandated as per the scheme at first instance, and she had categorically mentioned it in her representation that she wanted to withdraw her VRS option, it was incumbent upon the respondent to consider and act upon it. It is not the case that it could not be done, since the competent authority had the discretion to accept or reject. The competent authority should have considered the case of the applicant, since she had done it well within the stipulated period. Accordingly, we find the action of the respondent in not considering her options and representations for withdrawal of VRS as illegal and bad law. Therefore, the impugn order dated 2/1/20 and 31/2/20 was for the applicant, his concern is quashed, and the respondents are directed to consider the case of the applicant for reinstatement in accordance with the rules and informality and pass consequential orders as regards it to within a period of 90 days from the date of sworn.
What is wrong in it?
My humble contention is the tribunal though recorded the clause 3. The proviso cannot be supersede matter. The first once you have committed again and again.
The first withdrawal is not complete withdrawal.
No matter that is
that would have been completed once the hard copy is
submitted. The Lord Tribunal though quoted the para clause 7.3 my lord, you also can again see that.
Or it only says reconsider.
Page 67 my lord. The top my lord. The options are exercised. Once exercised under the scheme shall be final, and a decision of the competent authority shall be binding on the concerned employee, provided that the employee will be allowed to withdraw the option only once at any time. That wording is very close, cut-off mark is my lord once. Therefore, the proviso when specific clause has provided that you have to exercise option once my lord, that has been he has exercised.
There may be some small problem. He has done it in the same day. Quick succession. In a quick succession.
My lord, kindly appreciate my lord. She has applied, withdrawn. All right, my lord. But again applied, again withdraw.
Maybe some technical problem or something.
The system has not accepted it. Therefore, he has a hard copy on 25/11/2009.
The scheme has contemplated that situation. Therefore, the scheme also says that hard copy is necessary. Sometimes the system may not accept for some reason. So therefore, hard copy is mandated under the scheme.
My humble submission is that she has not challenged that 7.3 my lord. Once.
You see, why such a thing is there?
My lord.
But suppose somebody thinks of going for the VRS, he may be for some compelling reason, he might be thinking.
A reluctant worker. He wants to leave the.
So let us say the period is there. He's saying that yes, by this then something again cropped up his mind, let us go again. So that is how the time has been fixed that he has got the option to. So at the authority concerned to at least wait till that date. It should not be hurriedly done because because the scope of changing the mind, as in this case has happened, the scope of changing the mind to withdraw the VRS, that is how a time limit has been given for 1 month.
The object and purpose of the scheme, my lord, because the BSNL is going through a very bad position to downsize the corporation's employee, and the lordship you can see the object and objective, page 20. The scheme aims at optimizing and right-sizing human resources of BSNL by providing attractive benefits to the eligible employee opting for voluntary.
Mr. The option once exercised means the option which he had given that should be in accordance with the procedure, and that would be a valid option if it is if the request is made online and with a copy of the hard copy. If that is not there, then that option is no option. That is exactly what has been held.
What the land tribunal says, I agree with my lord's view.
You said that he has accepted that money you might have transferred to his account.
No, my lord, he has accepted also the part of the pensions he has accepted.
No. But
in the prayer,
obviously, if now you allow him to join, so that thing you can take it from that person, or it will be adjusted from the salary. That's a different matter. Money is not a matter here.
My humble submission is, my lord, the scheme itself when provided a particular way. That means, my lord, this once so far the crux of the issue is withdrawal. Withdrawal you can exercise once. Withdrawal cannot be more than once. That's why the system has not accepted it. Thereafter, after on 25/11, this is the situation on 8/11. 25/11, she has filed a representation for the first time with hard copy for withdrawal of the representation before the authority. There is no system for the my lord by content. Lordship, I bring that here is a case particularly, my lord. Once you have submitted the applications and release the pension amount, that is, my lord, State Bank of Patiala, which is Fulvati. The only I bringing to my lord's last paragraph. Relying on another judgment, the Honorable Supreme Court says, the instance that the factual position clearly show that the late so and so had tendered his resignation, which has sought to be withdrawn, but the withdrawal was not accepted, and subsequently there was a reiteration of the prayer for voluntary resignation. The inevitable conclusion therefore is that the High Court has not justified interfering with the order of appellant bank, relieving late so and so, consequent upon accepting his prayer for resignation. My humble submission is here is a case, my lord, twofold. Once, he cannot be permitted, she cannot be permitted to exercise her withdrawal option more than once. Which he has done, which the system has not accepted. Basing on the available system, I have annexed the annexure 2 and 3. Basing on the available material on record, the authority has proceeded ahead and assessed the financial assessment, financial liability.
How your system accepted for the first time?
First time, but as for that 7.3, the system will accept for withdrawal for once.
Provided that it is made with the signed copy, with the hard copy.
Come to page 27. Come to page 27. 6, clause 6.
The eligible employees shall fill the option from through ECS portal
and take 3 printout. Sign all of them in blue ink.
And submit the signed copies of their respective controlling officer within 3 days of submitting the online option. One copy will have to be posted in service book. Second copy will be sent to the competent authority for acceptance of VRS. And third copy, the employee will take acknowledgement thereof.
She has done it on 25/11/2019. Okay, when he has withdrawn?
On 8/11.
18?
8/11.
8/11. 8/11?
From 2019. Physical copy was filed on 25/11/2019.
25/11. No, withdrawn. When has he withdrawn? It can't be before that. When has he withdrawn it?
She has written 8/11, same day.
Same day.
After few hours, my lord. There is no dispute regarding that, my lord.
What is the age now?
Is 56, 58.
56. Hard copy join the 25.
Women how to file phone you also be as
Same bill na.
same sabuda same day right.
Second
last
second ta kebe withdraw kala. Second ta kebe withdraw kala. Second ta kebe withdraw kala.
Second
Hard copy se dala 25.
My lord has pointed out 27 clause 8 and 9.
Yes, what do you say?
My first submission, my lord.
You are a very reluctant worker. You don't want to work.
Unsettled mind.
So
File kardele VRS punu withdraw.
in already she has done so much. So my lord, my first submission. The
What is your age, by the way?
56, my lord.
You have already availed also the
no, my lord.
of the. Are?
No, that is my specific stand in my counter. For first time, this plea taken before my lord.
May I have annexed that document, my lord?
No.
So at para 5, I have denied the same, and my learned friend has enclosed the counter. There is no such pleading. Moreover, my lord.
Roger, just a minute. Where in the counter affidavit you have stated that you have paid back all the dues and he is now getting the pension amount also.
What is your age now?
56, my lord.
Age of superannuation is
60.
60.
So we will adjourn this writ petition for another 4 years. You will automatically subordinate.
So my lord, the counter filed on tribunal is Annex of 10 starts from page 58, my lord.
Counter affidavit, you have not taken the count of this thing, Mr.
And so far pension is concerned, my lord, I have not submitted any paper relating to my superannuation, my lord. That is my specific stand. By filing a reply to my IA, they have said that I have not submitted also, for which they have granted sanction me provisional pension for 4 months. They stopped it, my lord.
See the document of the pension payment. So nation se nije mana karchane amu debeni jehetu wait pending achi more. Party payment nation, so all the documents have annexed.
Jabardast dele nebo pudi hobo. If actual disputes at all have been appreciated by the tribunal, where is the perversity in the finding? You want interference by this court, unless you show the perversity. Why should you interfere?
My humble submission is, my lord, the tribunal has taken note of the clause 7.3 that regarding withdrawal. One cannot withdraw the application more than once. Having done so, in para 7, para 9 says there is no option according to law.
No, but tribunal says that the option under that provision is redundant because it is not complete. The first exercise was not complete exercise.
But then also
the second was complete exercise.
This is a proviso. This is a proviso clause 8, my lord. I have lordship has rightly brought to my lord page 20. Para page, regarding clause 8 and 9. Para 6 clause page 27, 6, 7, 8 and 9. 899 में मतलब employees लिखा है clear employees are allowed to withdraw option only once during the prescribed period of exercising option. Therefore, once is very vital, has taking a very vital position because otherwise the objective the entire scheme will frustrated. If suppose my lord, because available materials on the system, the process are financial benefits are not assessed, and according it is for. That is what the my lord the Pulpati case Supreme Court once we accepted.
See, ultimately, it was a scheme. You got rid of many employee. He wants to work.
Which decision you are citing? Which decision you are citing?
My lord, my lord, copy this.
Which paragraph?
Last paragraph.
A complete and effective act. Read it.
In the instant case, relevant the instant case, factual position clearly shows that Hariram had tendered his resignation, which was sought to be withdrawn, but the withdrawal was not accepted, and subsequently there was a reiteration of the prayer for voluntary resignation. The inevitable conclusion, therefore, is that High Court is not justified in interfering with the order of appeal and back, relieving the late Hariram so with effect consequent upon accepting the prayer for resignation. The judgment is accordingly set aside. In that case, Hare exercise kale, withdraw kale.
No, that was not. This is not under the scheme. It is the regular resignation.
No, that is under scheme.
Where is that? Where is the scheme? It's not under the scheme.
No.
It's not under. It's the regular resignation. It's not under the scheme. VRS scheme. The scheme comes, it's a different story altogether.
Are the counsel and counsel for the petitioner and counsel for the opposite party? This petition has been filed by also challenging the order dated 25/4/2024 of the London Central Administrative Tribunal, Cuttack Bench. So also the order dated, if you take it from that, we have already dictated that one, you from the para 18/12/2024, we have given all those things, so on, so on, so on, so on. Okay. Para 2 The Land Council for the petitioner has referred to the scheme which is annexed to the petition as annexure 1. The scheme is called BSNL Voluntary Retirement Scheme 2019, and it indicates that the scheme shall remain open from 4/11/2019 up to 3/12/2019, 5:30 p.m. And the effective date of voluntary retirement under the scheme will be 31/1/2020 afternoon, A/N. The relevant portion of the scheme was placed by the Land Council for the petitioner, which states about the procedure to be adopted in submitting the option to voluntarily retire from the service. And clause 7 deals with the same. And the relevant provision is enumerated here under 7 bracket Roman 3 like that. The step-by-step guide for exercising the option has been is also there as a part of Annexure 2, and the same is quoted here in below. 6টা লিখে দেবেন, eligible, that is at page number 27. The contention of the learned counsel for the petitioner is that the employees were required to take a printout of their final option, opted or withdrawn, on the ESS portal and submit the same to the controlling authority for further processing it as per the administrative requirement under this scheme. And submission of the hard copy was not a mandatory prerequisite for withdrawing the option of VRS. While opting for VRS or withdrawing it, the employees could see the approximate benefits of the VRS and also choose to decide later to a given tab on the portal. And therefore, the option subsisting on the ESS portal at the end of the option period, that is 5:30 p.m. on 3/12/2019, was to be final. The necessity of submitting the printout bracket hard copy of the subsisting online option was only related to the final option on the ESS portal. And an employee was not required to submit the printout of every changing option. It is the contention of the learned counsel for the petitioner that the final subsisting option on ESS portal at 5:30 p.m. on 3/12/2019 would have the effect of obliterating the earlier options withdrawal. It is further stated, argued that more than 78,000 employees of BSNL opted for VRS under BSNL BR Scheme 2019, and all of them have retired from service with effect from 31/1/2020 as prescribed under the scheme. And those cases have also been settled with all payments, that is ex gratia, EL, encashment, GPF, commutation of pension and gratuity under the scheme. So far as the case of the opposite party is concerned, all the three options, that is opting, withdrawing, and then again opting, were completed on 8/11/2019. And it would be evident that the only last online option, that is opting for VRS, would survive as per the scheme. The opposite party choose to write an application on 25/11/2019 for withdrawing the subsisting online option for VRS. And no physical application was permissible under the scheme, and no controlling authority or competent authority were authorized to entertain such application for withdrawal, not submitted through online but physically. The Land Council further argued that the voluntary retirement of the opposite party was processed by the Circle Administration with effect from 31/1/2020, and the payments of ex gratia for an amount of rupees 23 lakh and terminal leave encashment of rupees 4,18,915 was also been made, and the Learning Tribunal has committed illegality in quashing the order accepting the voluntary retirement of the opposite party with effect from 31/1/2020, and ordering his reinstatement after 4 years of the VRS, and therefore the order is to be set aside. The Land Council for the opposite party, on the other hand, has filed the counter affidavit, where not only the order of the Land Central Administrative Tribunal is supported, but it is stated that the specific case of the opposite party is that she has not submitted the signed copy of the withdrawal of option along with the online application, and the signed copy was submitted only once on 25/11/2019, and therefore the cancellation of and it is further stated that it is further argued that the plea of payment of ex gratia and terminal benefits and receiving of pension has been stated for the first time in the writ petition, and there is no such pleading either in the counter affidavit which has been filed before the Learning Tribunal or the additional counter affidavit or the additional counter. The Land Council for the Land Council for the petition opposite party submitted that the Learning Tribunal is justified in passing the impugned order and also dismissing the review petition and directing the petitioner to consider the case of the opposite party for reinstatement in accordance with rules and formalities, and to pass the consequential orders. The Land Council for the petitioner has placed reliance in the case of State Bank of Patiala versus Phoolpati reported in Swansea Supreme Court cases resolution that set 2005 3 SCC Swansea, wherein it is held as follows. For this paragraph, the underline is etc. After going through the impugn judgment, we find that that was not a case under a particular scheme. In the case in hand, the London Tribunal, after taking note of the pleadings of the parties and the contentions, and also the provisions of the scheme, as per clause 7 and 8, has come to hold as follows. Quote paragraph number 9. In view of the scheme, it is apparent that even though it is mentioned that the option once exercised shall be final and the decision of the competent authority shall be binding on the concerned employees, but so far as the withdrawal part is concerned, withdrawal of the option is concerned, even though it is stated that it is to be done only once till the closing time and date of option, but it further requires that the request of withdrawal of the option shall be submitted online along with the signed copy in writing. Therefore, when the first option was given, no hard copy was submitted, and it was only submitted on 25 kete se tarikh na? 25/11/2019. And therefore, the London Tribunal is quite justified in holding that as observed in the paragraph number so and so. Therefore, we do not find any perversity in the impugned order dated so and so, and also the order passed in the review petition. Accordingly, we find no merit in the writ petition and it's dismissed. Yeah. Nirmal outside, and Mr. Please give the name also. Yes. Mr. Palit, you are mentioning a matter. Who is
19, my lord, I am there. I will take 2 minutes.
Mr. Palit made a mention in the first hour. In fact, we proposed to take it up at 12:30, but we are dictating an order, so it could not. So all these left out matter will definitely come on Friday. So don't worry, we are not taking it out of the list. So Mr. Palit, can it be finished within this short time?
I'll have to implement they have some auction has happened. They have
okay, the auction part stay will continue to you. The auction will go on, and the
will not be confirmed.
now sale has been.
They have made an auction, and some bidder has come and bid at 12 crores 12 lakhs.
Now
12 crores 12,000 30 lakhs.
So now that
I have to implement,
right.
like you got it.
You know that who is that person now.
He has given the name. Name has been given.
I've given the name.
Please file an interim application then.
File an interim application.
Who is that person? Who is?
So some Federer's company from UP.
Which paragraph, Mr.?
Paragraph 4, madam.
Paragraph 4.
Federer's Electric Engineering Limited.
Just
Immediate take out notice.
And take out notice.
left on the. An affidavit has been filed. It has the item number.
36.
36.
36. All right, Mr. Das and senior advocate appearing for opposite parties number 2 to 4, na?
Yes,
2 to 4 has filed the affidavit of the general manager of the OSFC, in which the paragraph number 4 is stated that one so and so is the highest bidder with a bidding price of ₹1.
In the auction held on such and such.
And
On the auction held on such.
on the auction
Held on.
which was held on kebe auction
5th of July.
5 July na
5th of
5th
July.
July 2025. The copy of the affidavit has already been served on Mr. Khalid and senior advocate, who intends to file an interim application to implead the highest bidder as one of the opposite parties in this case. At least this matter, kebe rakhiyo as hoga?
Mutike
21st.
You are to file.
22 তারিখে রହୁনি
नहीं से हमें गोटे इंटरिम ऑर्डर पास करछु जे फाइनलाइज करि परिबे
Finalize
नहीं in the meantime list हो because हमें notice नहीं
हां मु से
बाकी formalities complete कर दवा
सेगुडा को कंप्लीट कर दियंतु बाकी फाइनल हियरिंग्स ताको नोटिस टा पड़े जाय नेक्स्ट वीक रासु एथ पई आपण टू पास एन ऑर्डर ऑन द इंटरिम एप्लीकेशन सो let it be on 14th. What is
14 my
just formal application is being filed. This matter on 14th of July 2025. The interim application for impleading the highest bidder be filed in the meantime, serving a copy on Mr. Das.
And I also filed an IA 11407 of 2025. I filed it today, my lord. That may be taken on record. I've served a copy on my pen.
What is that I? What is that I?
I have prayed for to undertake a joint inspection of the asset seized.
Ajay sir, mogi di undu se ayo ta.
11407 of 2025.
Mr. Khalid and that he has filed an interim application, which has already been registered. Which is registered as a which they have. The interim application is taken on record. The copy of the interim application has also been served on the Mr. Das, who intends to obtain instruction also on that interim application, right? So this will come on 14th, right? Interim order, obviously. The interim order based with so and so shall continue till next day.
Just informally manner that that will continue till the final hearing. I'll come back.
Yes.
Grateful.
You matter, what is that matter? 19 on short matter will be found.
Yes, my lord. Here, my lord, the Lord Central Tribunal has rejected my amendment petition.
Who is for the Union of India?
Yes, where, my lord? We are appearing.
My lord, my amendment petition has been rejected on the ground that hearing had already started. Matter was part heard. Your lordship may kindly the last order that your lordship had passed, kindly see the time. After hearing me,
no, we passed the order on 21/11/2024.
Yes, my lord.
So just read out that order.
My lord, after taking note of the submission that I made with regard to the factual aspect, your lordship directed in that last but one paragraph. Let me kindly come to that. When you made the query to Mr. P.K. Patil, then
index to the
when you make the query to Mr. P.K. Patil and the DSGI appearing for the opposite party 1 to 4, as to whether there is anything on the record that the order under Annexure 3 rejecting the representation of the petitioner is communicated to the petitioner, he seeks time to obtain instruction. My party has filed an objection to my petition right now, my lord. I'm just taking your lordship to paragraph 8 of that.
Counter affidavit.
Yes.
Paragraph 8.
Paragraph 8 of that affidavit, my lord.
Okay.
Counter affidavit filed by opposite party number 4.
Hold on.
Just read it.
My lord,
In response to the
in response to the amendments in para 6 of the petition, it is humbly submitted that the order dated 30/4/2019 was available in the petitioner's file. And when the opposite party, number 4, came across it, filed before the London CAT on 6/3/2024, and at present it is not possible to confirm whether it was delivered to the petitioner during the time of issue. Any record in support of the delivery is available in the file. My lord, this rejection order of my appeal was passed during the pendency of the original application itself. Neither in the counter nor in the additional counter filed by the opposite party that document was placed before the tribunal. After 6 times, the matter was heard in part for 6 times. Thereafter, the government council filed it along with the affidavit, to which I wanted to bring it by way of amendment and filed a petition. I said that it has not been brought to the notice of this honorable tribunal, nor it has been communicated to me. Now the tribunal has rejected it by saying, no, since it has been, it was accepted by the tribunal, and the rule is, my lord, section 19, subsection 4 says that should have been ignored. Because it was passed after the original application was admitted, my lord. Despite that, they accepted it and it's rejecting my application by saying that it is my amendment petition has been filed after the matter was parted. That is the case.
Yes, my lord. My lord, it is a case where they are brought to the notice of the Land Central Tribunal, which is document is a separate cause of action. It should be challenged in a separate way. It is not that it will be amended threshold under the present dispute, because it is a case that 2014 is the extra. It was well known to him, and neither he brought to the notice of the tribunal, nor it can be it was on the record to adjudicate. Subsequently, the later stage it has come, for which we will file an objection. Let's see for a moment.
That was during the pendency of the OA. That was during the pendency of OA.
Yes, pendency, and we have filed a MA, then we have filed an objection. That is.
Why don't you file a fresh OA?
Yes, then it will be adjudicated by this process.
I have filed page 62. I made the representation to everybody, and finally I made a representation to the CPMG by name, agitating that please see to this grievance, my lord. The grievance that I have made in the original application, that was rejected during the pendency of the original application. They brought it by way of
rejected since long.
That it has been rejected. And when I
rejected since 2019, in the time of education in 2024, they are coming and brought to the notice of the tribunal to educate by inserting this document. How it is possible? If a fresh cause of action is file a fresh application and it will be disposed of, or analogously it can be disposed of. Not by this process. Rightly, as tribunal has passed such order.
The objection
different cause of action, different issue.
In the objection, they have filed, my lord.
Work no pay and ex gratia is completely two different issues.
Come to the order, that 29/4/2024 order. That is annexure 1. Please place that.
Lord, may kindly come to page 92. The objection.
Just trace it one go again.
Read the impugn order.
Then
annexure 1.
Yes, my lord. Annexure 1, my lord. Page 30.
Yes.
But both the sides, London Council for the applicant submitted that he has filed MA number so and so for amendment since after completion of the pleading and matter being heard continuously. Respondent on 21/2/2024 produced order dated 30/4/2019, whereby order of the CPMG rejecting the prayer of the applicant for grant of full TRCA of the put off duty period and confirming the order of the disciplinary authority. He submitted that the respondent had not filed the same during the file of the counter, reply to the rejoinder, etc. He submitted that the order dated 30/4/2018 needs to be challenged after for better adjudication of the OA. London Council for the respondent submitted that he has filed objection to the MA, taking the ground that besides the proposed amendment would change the nature and character of the case. The amendment shot during being filed when the matter was heard in part, the same is liable to be dismissed. We have considered the rival submission of the parties and perused the record. We have also gone through the Rule 17(6) of the CAT Procedure Rules 1987, wherein it has been provided that the tribunal may permit the parties to amend the pleading in the same manner as prescribed in the Order 6. Code of Civil Procedure 2000 in provides to the said rules. The amendment 2002 restricts the power of the court to allow the amendment pleading at any stage of the proceeding. It says that the court cannot grant permission for amendment after the trial has commenced. It is not in dispute and cannot be disputed that the pleading in this case are complete. The matter was also heard in part, and at this stage, the applicant filed this MA seeking
Mr. Paddy, can you?
Yes, no, since it arises out of the almost same cause of action, it is just a thing which was not in the notice of the. So again, if he files fresh application, then what is to be the notice has to be issued. You are to file the counter affidavit once again, and then both the matters are to be heard together. So why not? If we allow if the amendment is allowed, then you will also get the chance to just forward that portion.
But it is a new proceeding, my lord, just as let me see.
It is
rule 6, 7.
It is not a separate cause of action, rather it is a continuing cause of action.
No, my lord.
Pardoning a litigant to file a separate petition is only exercise in futility. Why can't the amendment be carried out and the matter is disposed of?
I'm just trying, within 2 minutes I'm clarifying, ma'am. There the application in respect to this present way is for execution. And he is claiming the application for getting about the full pension, full execution payment. And that is that application was rejected. And this Rule 6, Order 6, Rule 17, just I am reading the provided, my lordship, in CPC, provided that no application for amendment shall be allowed after the trial has been commenced, unless the court comes to a conclusion that, in spite of the due diligence, the party could not have raised the matter before the commencement of the trial. What happened in this case is a complete new to this case, the complete nature and character of the case will be changed. That's why we have filing objection. If it is a similar in nature and it can be educated analogous, we don't have any objection. But by inserting this document, the entire proceeding will be changed. Then prayer will be amended. We will fight again objection for the same. Again, fresh hearing will be held. That's why what I am suggesting, my lord, is lordship is saying that it is a part of, is a same petitioner, there is a getting claim, it is all right. But character, nature and character of the claim of the petition is completely changed.
What was the prayer made in the first and what is
yes, my lord.
The prayer in the original application was that ordered.
My lord, this prayer is put up in duty. Just
original application prayer.
Original application prayer or abiju application prayer.
The prayer in the original application.
Can we find that way?
Page 28.
28. See the prayer, let us see.
My lord, 8A was the part of the order in which the period of suspension is treated as no work, no pay for all purposes by Annexure AY5 and also order under Annexure AY12, where the superintendent of post office has requested the CPMG Odisha Circle to review and treat the period of suspension as a duty for the purpose of pensionary benefit.
Okay, that relates to that suspension period. Now, what would be the new prayer if that means the agent order which you will challenge?
My Lord, your Lordship may kindly come to Annexure 9 to my original application. Page 62. This document was
Party is making a specific submission that if we allow it, then that would be a completely different prayer than what was prayed earlier, and it, in fact, it gives a fresh cause of action which you are required to file a separate original application for the better adjudication of the case.
He is wrong, my Lord. Your Lordship may kindly come to Annexure 9, page 62. Page 62 of the writ, my Lord. This representation was disposed of. After 8-time hearing of the matter, my Lord, the order that order was placed before the tribunal by the respondents, my Lord. I'm taking your Lordship to that, my Lord, page 62, your Lordship.
Yes, we were in the 62. Yes.
My Lord, I have made this representation by name of the CPMG, my Lord.
Yeah.
Since none of my earlier representations were answered. Most reasonable, most humbly, respectfully, I beg to state that I was placed under put of duty for a period of 8 years. Lastly, I was condued, but my allowance, which was getting prior to my put of duty, has not been refixed. I joined on 23/9/2014. That the workload after my joining, the workload of the office was very heavy. The senior superintendent of post office Noyagarh is to collect the statistics for revision of the TRCA. I came to know that the inspector of post Noyagarh is subdivision sent the statistics on 12/12/2015. In the meantime, the period of 1.5 years has passed, but I have not been paid my revision TRCA. In this connection, I have also sent 3 petitions on so-and-so date, so-and-so date, so-and-so date on so-and-so date. Not a single reply has been given to my above revision petition by TRCA on workload basis. And also on the regularization of my put of duty period. Since the charge of allegation for major penalty was not justified, I'm entitled to get the full benefit of the TRCA, which may kindly be considered and paid to me early. This period is not. Just one line more, madam. But pardon? Yes, madam. That was prayer 1, prayer 2, my lord. That was rejected, and it was not communicated to me during the pendency because the normal course it has not been communicated.
I am not that point, man. Sorry. So,
Okay, then your question.
No, CRL.
The petitioner is about
CRL 319 to 2025 for bail.
The petitioner is under custody for about 9 years. Give it. Actually, is like it in CRL 46 to bail.
One CRL 1178 or 22 million. That was directed to be listed first.
Where is your court? You are not in uniform. Court gown padala.
Sorry,
Yes.
Supplementary list, item number 1.
My lord, serial number 707/2025, conviction for life. Offense committed under section 302, 201, 30 of IPS.
Admit
Yes,
for the prior court record. Interim application for bail and stay relation of fine to be considered after receipt of the trial court record. Deposition copy to be supplied to the land council for the state in the meantime. Same order for the Hon'Ble person. Alright? Yes.
So serial number 586/20.
Sabuda fresh admission na same. Yes.
Item 2.
That's item 2. I'm there virtually. The conviction is at page number 52. Internal page is 43 of the judgment under section 302 and 201, imprisonment for life, my lords.
Okay. Same order. Admit. Yes, next.
Item 3.
3 admit engage कर देगा देखेंगे तापर यूजर engage सब और
Item 4.
वो लाइफ तो
Like
लाइफ में डिले कॉन्डम कर देगा एडमिट कर देगा
item number 3, the one of offenses is POCSO, so notice may be issued.
so no let him कर देगी ना engage करा दियो है ना yes
Item 5.
Item 5, Lord. Lord, item.
In item number 5, can I pay for next week? So Lord, should I directed me to call for the conduct report? Still awaited as a last chance.
Lord, in this case, Lord, I have in this case I have filed a bail application for bail, Lord. Already 600, Lord.
bail application it is there Mr. Patnaik it is IA number 132 of 25
My lord.
so no the state council is seeking some time to obtain instruction as per the previous order so you're granting him
One last chance.
okay
Can I pay for
the
next week?
Lion Council for the state seeks some more time to obtain instruction in view of the previous orders passed by this court, out of this matter.
Next week, anything?
Next week, yes.
Item 6.
May your lordship please often instruction custody certificate.
First call for the custody certificate as well as the conduct certificate may be permitted.
Nine years, 11 months.
My lord, my lord, he is the custody. Man, he is arrested 319, 38 by the year 13. Parallel ଯାଇଥିଲା my lord, ସେ ଗୋଟେ ବର୍ଷ 1 year
10 months, 27.
10 months 27,000. But
all right, 9 years, 11 months.
10 years my lord.
10 years कौन?
10 years मतलब custody period.
किम दिया थी वो? तो जाइची parallel period that is not to be included.
My lord.
Are you aware of or not?
Yes, my lord.
So if you are aware, then why are you arguing the matter?
My lord, the total period man 11 years, 10 months, 22 days. But parallel, my lord, 1 year, 10 months, 27 days.
He was released on bail, interim bail. What about his conduct?
Conduct is good. They have
No, conduct.
conducted that. They have accused some.
Oh, sure. Further inquiry, there are no objections from.
There is no adverse report against him.
No adverse report for लगाएगी.
Pardon me.
It's not written, but you are inferring.
They have written that they have made an inquiry in the village, and they said that if the applicant is released, then they have no objection regarding the. That is the covering letter. They have encouraged.
When you are granted interim bail last time?
Last time, my lord, interim bail granted 21 days.
23/3/2018.
18.
And your bail application on merit has been rejected earlier.
11/11/2016.
Oh. You poured kerosene and set fire to the deceased.
There are burn injuries.
You are the husband, and the deceased is the.
You could not explain in which circumstances.
My lord, PW 6 and 9 says at that time he is sleeping at Mondop, my lord, outside.
Married to the or the Learning Council for the Petition Learning Council for the State. The Learning Council for the State has produced the written instruction received from the jail superintendent to show that the petitioner is in judicial custody for 9 years, 11 months and 5 days. And he has also obtained instruction from the in charge Deputy Superintendent Police Pulwani Sadar Police Station that during the nothing has been written about his conduct. Just let them. The villagers have no objection if the petitioner is released on bail. The reports are taken on record. But we are not writing anything, but just intimate he's a deputy superintendent of police. It was the court sought for about the conduct during the interim bail period. Uttara lekha aichi je if the appellants are released on bail, the villagers are have no objection. That is not our query. That
Yes, the villager signature.
Villager signature.
That is more.
ये तो तांको कोई नतला में विलेजर को ओपिनियन मांगिया पाई बस लेकिन taken on record considering the submission made by the learning council for the respective parties and in view of the available material on record and the fact that once the bail application of the petitioner on merit has been rejected by the order dated 11/11/2016, they are not inclining to release the petitioner on bail on merit, but taking into account the detention and absence of any chance of early hearing and the issue let down in the case of Leti, 3 months will granted. Yes.
Sterilization.
And he has to file the surrender certificate. Yes.
Sterilization.
Sterilization of financial. Miss case number so on, so sterilization. Right.
Item 7.
You have the two appellants. Two appellants. They are convicted under 302 and 34 of IPC.
Have you filed the bail application for both the appellants?
Yes.
Okay. You have filed also your V-Nama.
Yes.
Lekon. Prisoner's petition has been received to engage Mr. Pulokesh Mahanti in place of late Durlabh Ranjan Mishra. Mr. Mahanti has already filed Vakaratnama, which is accepted. The name of Mr. Durlabh Ranjan Mishra shall not be reflected in the cause list. You are appearing for both, no?
Yes.
So also Mr. Niranjan Panda. Hello. So how many years you are in custody?
8 years, 3 months.
Whether your bail application was earlier rejected? Yes, madam. By the order dated?
By the order date 8/6/2021. Little over 3 years in custody, but it's not considered at that time.
No, that time it was rejected because he was just 3 years in custody and liberty was granted to move at a subsequent stage. So if it was rejected on 21, that means you are in custody for 7 years now.
8 years, 3 months.
କୋଉଠି ଆମ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ କଣ ସେତେବେଳେ ଆପଣ ଯଦି 3 ବର୍ଷ ହେଇଥିଲା 2021 ଜୁନ ମାସରେ
Before, at the time of arrest, he was, before releasing on bail, he was in custody for,
ଯାହା ଅର୍ଡରଟା ଲେଖା ହେଇଛନ୍ତି ସେଇଥିପାଇଁ ପଡୁନି
judgment ପରେ 3 ବର୍ଷ ରହିଥିଲେ ବୋଲି ଲେଖିଥିଲେ.
since the date of judgment of the trial court a little over acha, okay. So what is the custody certificate? Get it that custody certificate and also criminal antecedent if any. When the learned counsel for the appellant submit that the appellants are in jail custody for more than 8 years.
Yes.
Learned counsel for the state seeks some time to produce the custody certificate. So also to take instruction regarding the criminal antecedent if any against the appellants.
And jail conduct.
And the conduct of the petitioner in jail also. Yes. What is the for of the
Item 8.
The petitioner is in near 10 in earlier bail application, the Honorable Court directed on 22nd
just a minute.
September.
Please. There is only one appellant in this case.
My lord.
Anand Naik.
My lord.
So he has filed one prisoner's petition to engage Mr. Karunakar Naik. Then he filed another petition to engage Deepak Ranjan Mishra in place of so. Another prisoner's petition has been filed to engage SK Jeprullah. तापरे पुणी गोटा पिटिशन फाइल कला टू एंगेज मिस्टर अरिजित मिश्र ते कौन कहीं काम ना ना कौन पुणी गोटा पिटिशन फाइल कला नीलमाधव प्रहराज जी ओडिशा हाईकोर्ट जी एडवोकेट समस्त एंगेज कर
Two cases, my lord. Both the cases, my lord, the appellants are on interim bail for a period of 3 months, my lord. Thereafter, they surrender before the court, my lord. And then certificate is there, my lord. Surrender certificate there. Last of all, you will also direct State Council to obtain the conduct certificate and conduct, my lord. Obtain.
দুই বার কষ্ট রয়েছেন no others.
No advocate.
Heard the Land Council for the petitioner, Land Council for the state. The Land Council for the petitioner submitted that as per the order dated 6/11/2024 in IN number 2365 of 2024, taking into account the period of detention of the petitioner since 3/12/2012 and that there was less chance of early hearing of the appeal. This court, taking into account the ratio laid down in the case of Leti alias Jayadev Rai and another versus state reported in so and so, directed the petitioner to be released on bail for a period of interim bail for a period of 3 months. The further submits that after availing the interim bail period, the petitioner surrender at right time stopped. On the last date, he asked the Land Council for the state to obtain instruction regarding the conduct of the petitioner while on interim bail. Today, the Land Council for the state has produced the written instruction received from IIC Nagar Police Station that no adverse conduct has been reported against the petitioner during the period of interim bail. The written report is taken on record. Considering the submission made by the Land Council for the respective parties, period of detention of the petitioner in judicial custody, and fact that the petitioner has not flouted the terms and conditions of the interim bail order, we are inclined to release the petitioner on bail allowed.
Item 10. What about the second item?
Second item is co-appeal. Second note, there are two appellants, my lord. One appellant, my lord.
Second item.
Same.
No,
same মানে তার রিপোর্ট কন্ডক্ট নেই
I give you no comment.
সেইথির ଅଛି
ফটোকপিটা
এটা পরে না লেখা ହେଇଛି ଦିନେଶ ମାହାতো ଲେଖା ହେଇଛି ସେକେଣ୍ଡ ଓ ଆଜି ଦିଟା ଆପଣ ଦେଇଛନ୍ତି
ସନ୍ତୋଷ ପ୍ରସାଦ ମାନ
ହଁ ସନ୍ତୋଷ ଆଚ୍ଛା ଆଜି ଦିଟା ଅଛି ହେଲା
ସବୁବେଳେ ଚନ୍ଦ୍ରମୋହନ ସେ are acquitted by this court since 10 years custody.
ସନ୍ତୋଷ
where is the original
conduct report of in respect of Ramjial response. ଏଥିରେ ଯୋଉ 488 ରେ କେତେ ଜଣ appellant ଥିଲେ?
There are two appellant, my lord. Out of the appellant, one, my lord, acquitted as because he is a juvenile and it remain 10 years and therefore we have filed IA and report confirmed he has been acquitted.
What about Chandan?
Chandan, my lord, acquitted.
Acquitted, okay.
Which order he has been for?
I'm not ordered.
But why has he filed the appeal then?
No, after it up.
2% during my lord, course of argument, my lord, I came to know his juvenile.
So that year,
reported confirmed.
before the juvenile.
And he has since 10 years in custody for that.
କେତେ ବର୍ଷ କୋଉ ଅର୍ଡରରେ ତାକୁ ହେଇଛି ଅର୍ଡର ପାସ୍ ହେଇଛି?
IA 280 of 21, my lord.
Order dated 10/8/2021. 17 years, 5 months and 12 days. As on the that was the order. Okay. ଆଜିର ଦିଟା ଅଛି ବୁଝିଲେ ଏଇଟାକୁ ପ୍ରଥମଟା ହଉଛି ଏଟା ଅଲଗା ଅଲଗା ଫାଇଲରେ ରଖିବେ ଏଇଟା ହେଲେ 487/2018 ହେଲା ଫାର୍ଷ୍ଟ ଆଇଟମ ଏଟା ହଉଛି ସେକେଣ୍ଡ ଆଇଟମ CR ହେଲେ 488/2018 ହଁ ଆଉ या नाम हूँ रामजी alias संतोष प्रसाद appellant number 2 हाँ बाकी से पीरियड समान ये जो
Period समान एक same date
सेम समान यस
Item 10.
Action plan of on behalf of Mr. Vishwadip Ranjan Tripathi. Kindly it will be taken up tomorrow.
tomorrow name next week it will come listen
Right.
what is your good name
Nitin Kumar Pradhan.
Nitin Kumar
Pradhan.
Grand Counsel appearing for Mr. B.R. Tripathi 6 for an adjournment till next week this matter next week yes
Item 11.
Lordship, my lord. After the lordship directly to obtain the instruction regarding the status of the
status of the
obtainment.
Status of the daughter of the petition.
The occurrence was in 1.5 years.
allegation that you have killed your wife
My
and you are blessed with a daughter your marriage took place in 2000
has been directed to obtain instructions. This is with regard to bail of the appellant number 1, who is in custody, my lords, having been convicted along with appellant number 2 under section 302 read with 120 BIPC, my lords.
I am for the inform.
This court, my lords, has granted interim bail to the appellant number 1 twice because of his illnesses, my lords. And he was on bail during trial also. Whether it is terminally, it can be treated as terminal illness.
Report is
Yes, my lords.
report is there at the bottom.
Fine.
But then
He is being on and off
There was a
the hospital and
refer to
outside.
MD medicine, specially in Noagar. After verification of the treatment records on Hariyar Pradhan.
No, terminal illness road definition achi. There is no chance of
which
survival.
is a terminal illness.
Food lekha
Doctor, what handwritten is the tole ଦେଇଛନ୍ତି ସେଟା. The basis of letter of the IAC 2/7 then 3/7 ର report में ହାତରେ ଲେଖି ଦେଇଛନ୍ତି treating doctor. The case of the DCM, dilated cardiological process, which is a terminal illness.
Where is it?
It doesn't also scheme to achieve.
Report and
See? Anauji Harihar Pradhan is not involved in any case except so and so. From the locality of village, it ascertained that the conduct of the food is during interim bail period. Baki terminal.
Is covered under the scheme.
कौन कहिबे अपन कौन कहिबार अछि
ନୟାଗଡ଼ ମେଡିକାଲ ସେଟା ମେଡିକାଲ ପଠାଯାଉ ସେଇଟା ରିପୋର୍ଟଟା ଇଏ ଅଛି ନା
ଏଟା ପୁରା ଆପଣଙ୍କର
ଏସି ମେଡିକାଲ
ଏଟା ଡିଷ୍ଟ୍ରିକ୍ଟ ହେଡକ୍ୱାର୍ଟର୍ସ ହସ୍ପିଟାଲ ର ଇଏ ଆଉ ସମସ୍ତେ କାଇଁ ଏସିବି କି ଆସିବେ ଆପଣ କଣ what is your ground why you disbelieve the a medicine specialist of the district headquarters hospital that this particular disease which is suffering from that is cardiomyopathy dilated cardiomyopathy, it is a terminal illness. So, hard Mr. Devasis Fonda, Land Counsel for the petitioner, Land Counsel for the state, Land Counsel for the opponent. As for the order dated 26/6/2025, the Land Counsel for the state has produced the written instruction received from Deputy Superintendent of Police in charge, Khandpada Police Station, which shows that the PS case records indicates that the petitioner is not involved in any other case except the present case, that is Khandpada PS case number 162 of 2020. It is further stated that during the period of interim bail, the conduct of the petitioner was good. With such report, another report submitted by the medicine specialist, District Headquarters Hospital, Noagar, dated 3/7/2025, has been annexed, which shows that after verification of the treatment records of the petitioner, it was found to be a case of DCM, dilated cardiomyopathy, which is a terminal illness. Stop. The documents produced by the Land Counsel for the
state is taken on record. Special campaign for old prisoners and terminal ill prisoners, which was initiated by the National Legal Services Authority, indicates
1.2.
In 1.2 that the prisoners with terminal illness face difficulties navigating the prison environment and require frequent health checkup, need special diet, and frequent meetings with family as a old prisoners and prison and which may not be possible to the 1.1. In view of such guideline and taking into account the conduct of the petitioner during the period of interim bail, we are inclined to release the petitioner on bail allowed. Prisoners with terminal illness out specially B so it has been report for the other. Yes.
Item 14.
Just a minute. Prisoner's petition has been received for engagement of Mr. Suryakant Trivedi in place of P.K. Sahoo. So, Wakalatnama has been filed. What is your good name? Huh? You have got the power in this case. Suryakant Trivedi ko jo Wakalatnama apno power achi. So you are an associate of Mr. Trivedi. What is your good name? Prisoner's petition has been received regarding engagement of Mr. Suryakant Trivedi in place of P.K. Sahoo. And the Wakalatnama has been filed by Mr. Trivedi, which is accepted. The name of Mr. P.K. Sahoo shall not be reflected in the cause list and spoke stop. What about the bail? Whether your bail application has been earlier rejected or
No.
first time must you? Have you gone through the order dated 24/6/24? चौबीस 6/2024 ଆପଣଙ୍କର ବେଲ୍ ଆପ୍ଲିକେସନ ରିଜେକ୍ଟ ହେଇଛି ଭେରିଫାଏ ନ କରି କେମିତି ସେମିତି ଷ୍ଟେଟମେଣ୍ଟ ଦେଇ ଦଉଛନ୍ତି your senior has not told you that the bail application was moved and it was rejected earlier. It was rejected earlier and that too on 24/6/24. Please see the order that is there. देखिले तो reject ହେଇଛି ବୋଲି order गुड़ा verify करी move କରୁଛନ୍ତି bail application आजिकली सब order गुड़ा को website रे upload होची हला तुम तो पढ़ी कि ना आसीबे तेणु आपनको bail reject ହେଇଛି so what is the change in the circumstance to consider the bail application afresh within a period of 1 year? What say he jama reject his bail application?
Have you prepared the matter or not?
Well, as for Nasa Kapan, the petitioner more than is 70 years.
70 years.
Say ground replication di.
2023.
So what is your instruction? You take the instruction. You see the paragraph number. पूरे इटा लिखा है जी तो ये टाइप रो केस बड़ा का आपण रेफर करिया कथा एक्चुअली जेल थ्रू रे रेफर होवा कथा Copy of the IA maybe. Oh, copy is not. Verify. Don't give such that how taku se 71 वर्ष. You must verify the documentary evidence also. Hala?
Jail से providing on the basis of documents.
जहाँ भी अपन जहाँ केमती कौन करिवे, we are taking you to take instruction. कारण सी गोटे लिखि दोची मोर एज होची एज अबाउट 71 years. आपण किछि न वेरिफिकेशन करिकिनी कर देबे हां तार ठीक कारण मेरिट रे ऑलरेडी वर्षे तळे रिजेक्ट हेची. इज नाउ सीकिंग फॉर बेल ओनली व्यू ऑफ दिस नालसा गाइडलाइन. अपन को वेरीफाई करिया पड़ियो प्रॉपर्ली.
Trial court judgment shows that 70 years.
Trial court judgment says 52 years in 2013.
But Sibo Kora.
Sibo Kora. You take instruction. IA number 1161 of 2025. There is an application for bail, and paragraph 2 of the interim application indicates that the petitioner is now aged about 71 years. And he was on bail during trial. The learned counsel for the petitioner also drew the attention of this court to the cause title of the judgment, impugned judgment, which shows that the age of the petitioner has been reflected therein as 70 years strong. However, it appears that the bail application of the petitioner has been rejected on merit as per order dated 24/6/2024. Stop. The learned counsel for the state submits that he has not received the copy of the interim application. Stop. Achi extra copy achi? So give him, let a copy of the interim application be served on the learned counsel for the state. Asanta kali vidal debe? Yes, by tomorrow. And the learned counsel for the state shall obtain specific instruction relating to the amendments made in paragraph number 2 of the interim application relating to the age of the petitioner. Put up this matter in the week commencing from 21st of July 2025. Yes. आपनकर नाटा देई दियंतु.
Item 15.
Item 15, I pray for adjournment. Mr. Ponda made an accident. I pray for adjournment.
He is well or is he serious? Well.
Thank you.
Okay.
But
Next.
taking rest.
Okay, it's all right. Mention is made on behalf of Mr. Panda for adjournment. Put up this matter. 21 तारीख रखिवा now.
Okay.
21/7/2020. Yes.
Item
Along with CRL and number font. Yeah.
Item 16.
May I please, Your Lordship?
Yeah.
May I please, Your Lordship? My Lord, here in this case, there is two appeals.
May please, Your Lordship. Which was granted permission, the appellant petitioner is being convicted under section 364A 457
Mr. Mishra आगु reject है जी.
नहीं आएगा.
कितने वर्ष वाला?
Lord, 10 years, 11 months, 21
Custody
days.
certificate?
Yes, custody certificate flag F. Your Lordship, may kindly.
302 case.
So 364A is that
judgment का या criminal appeal का judgment on
the appellant that was arrested on the allegation that
you are
the 1 year
kidnapped and committed murder of
child. You were kidnapped and subsequently the son died.
And appellate the
ଗୋଟେ ବର୍ଷ ସେ ଛୁଆଟା ଗୋଟେ ବର୍ଷ ହେଇଥିଲା
ଗୋଟେ ବର୍ଷ
ତା ନାଁ ହଉଛି ଅଂଶୁମାନ
ଆଜ୍ଞା and Millard, both there are two accused persons are there in the case of the Millard. Another accused was faced
you
trial
demanded rupees 10 lakhs over phone
10,000 subsequently 10 lakhs.
Then telephonic intimation was given from
Your short page 39, draw your lordship's kind attention to judgment, running page 39. The case is based on
circumstantial evidence.
My lord, case is based on circumstantial evidence.
What are the materials against you?
Material against me that one mobile phone was seized and the confession kindly see page 39, lordship so those. Running page 39, internal page 9. Last para. The London Defense Council has been successful in demolishing the prosecution case to the extent that the accused Sridhara was not identified by the informant at the spot by snatching the ransom bag. The material witness, Pandav Patra, the brother of the informant, is neither charge sheeted nor examined in the case to prove the nexus of the telephonic conversation relating to the demand of ransom by the present accused. Then, Mirror, I will take you to Lordship PW. Then the witness who was there in the police station, PW 14, that is your Lordship.
ଆମେ ପଚାରୁଛୁ ଆପଣଙ୍କ ଏଗେନଷ୍ଟ କଣ ଅଛି ଆପଣ ଆଗେ ଦେଖଉଛନ୍ତି ଆପଣଙ୍କ ଫେଭରରେ କଣ ଅଛି କଣ ପାଇଁ ଆପଣଙ୍କ କନଭିକ୍ସନ ଅଛି let us know that
yes
so what are the grounds or the circumstances which are available on record which has been accepted by the London trial court to convict you?
Yes, confessional statement 27 of the Indian Evidence Act. I have taken to the spot to.
What was recovered at your instance?
Recovered of the briefcase of the dead body of the child.
Oh, the dead body was recovered.
Yes, dead body.
So it was
last occasion your lordship was put. I posted to. And there are another accused who was your company, the party with this same crime, has been acquitted. Your lordship, last occasion was pleased to get a copy.
So, dead body of that 1-year child was recovered at your instance.
Yes, ma'am.
And PM has been conducted, and it was found to be a homicidal death case. And number 3, that money, ransom money, was also recovered.
So, that is not.
That is not.
He was not. The prosecution case that he came to collect the ransom,
collect,
but he fled away, and that was not identified. He could not be identified. This is, it was PW 23 is the father of the child informant, and it is there that he could not be identified, and confession statement is there. His confession and leading to 27 is there. To incriminating. There is another aspect the trial. I would like to bring your lordship's
ଛୁଆଟା ନା ତା ବାପା କଣ କରନ୍ତି ଯେ ଯାହାଠୁ ଡିମାଣ୍ଡ କଲେ 10 ଲକ୍ଷ ଟଙ୍କା what is the avocation of that man from whom you demanded ransom for 10 lakhs for the 1-year child?
I would like to draw the background. The statement of the wife, the child mother. Mother had given a statement, initial 161, and also deposed before the Honorable Court. There is another person was there who had also asked for 10,000 rupees. Mo Gayatri Patra aji 25/6 ରିଫରେ ମୋର ସ୍ୱାମୀ ପକ୍ଷ ନିଜର ଘରେ ଥାଇ ଉପରୋକ୍ତ କେସ୍ ତଦନ୍ତ ସମୟରେ ମୋକେ ବାନ୍ଧିଛି ମୋର.
What about the criminal antecedent?
He also is there.
Criminal just has to and এই টাইপର ଲୋକମାନଙ୍କର ଥାଏ ପ୍ରାୟ criminal antecedent. ଏଟା ମାନେ ransom demand କରିକିନି ଇଏ କରନ୍ତି ତ either direct ଥାଏ ନଚେତ ୟାଙ୍କୁ ସବୁ ସୁପାରି କିଲର ହିସାବରେ ନିଆଯାଇଥାଏ ଦେଖିନି criminal antecedent
flag criminal antecedent
ଅଛି
custody
Custody certificate আছে না?
Straightforward instruction regarding CA. You are also pleased to direct to
He has
obtain
not,
the
he
instructions
has
of
not
CA.
received that.
Let him recheck.
The London Council for the State seeks some further time to obtain the instruction relating to the criminal antecedent, if any, against the petitioner put of this matter. Paid the yes, next.
Item 18.
Yes, Mr. Five of okay, now next.
Item 19.
Got the 302 and 436. The 2 page of note is there, Lord, regarding finding and the things that went against me in the trial.
No, what is this matter? Traveling in Singapore, apparent has already surrendered.
ଗୋଟେ ମାସ ଯାଇଥିଲା interim bail ରେ।
No, why it has again come?
ନାଇଁ ଏଇଟା regular bail ଟା ଶୁଣା ହେଇନି।
Regular bail application ही नहीं। Have you filed any application? Okay. What is the application number? IN number कैसे?
Number 73 of, sorry, 115 of 2020.
Mr. नहीं, IN number?
115 of 2024.
ଆପଣ ଏମିତି କିଛି ଆପ୍ଲିକେସନ ପାଇଛନ୍ତି କି ରିସିଭ କରିଛନ୍ତି? କଜ୍ ଲିଷ୍ଟରେ ତ ନାହିଁ
interim bail ଟା ଯୋଉଟା ଅଛି।
ନାଇଁ ନାଇଁ ସେଇଟା ତ ଅଛି, ସେ ରିପୋର୍ଟ ଆସିଛି ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜଙ୍କର ଯେ ସେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଯାଇଥିଲା ଏବଂ ଆଫ୍ଟର ଆଭେଲିଂ ଦି ଇଣ୍ଟରିମ୍ ବେଲ୍ ହି ହାଜ୍ ସରେଣ୍ଡର, ଦ୍ୟାଟ୍ ଇଜ ଦେୟାର। ବଟ୍ ହ୍ୱାଟ୍ ଅବାଉଟ୍ ଦି ଫ୍ରେଶ ଆପ୍ଲିକେସନ which he has filed?
No, it was filed much prior to
No, that has not been placed on record.
Again.
Can you tell us the date? यहाँ पर किसी ऑर्डर था बट सेबल फाइलिंग 22/2024 से फाइलिंग 23 July 2024. When you were granted interim bail, that
last order was
12/5/2025 last.
oh,
17/1/2025.
the application which you filed subsequently, in that application you are already granted bail. So this application perhaps you on that was adjourned actually. By the order dated 27/8/24, this interim application was adjourned.
17/1/2025.
That is another application, that IN number 3 of 25, that was filed to release to take care of the mother. And interim bail was granted for 4 weeks. That he has availed and he has surrendered. So
Give the conduct.
obtain the conduct and also that
Custody set.
you have received the copy of that interim application.
No.
Give him a copy. Look on IN number 115 of 2024. Though this application is on record, but in the cause list, it has not been shown stop to be placed for orders. Stop. London Council for the State submits that he has not received the copy of the interim application. Stop. Let a copy of the interim application be served on the London Council for the State. From the report of the London Additional Session Judge Keonjhar dated 25/2025, it appears that after availing the interim bail period as per order of this court dated 17/1/2025, the petitioner has surrendered before the London Trial Court. Stop. Let the London Council for the State obtain instruction regarding the conduct of the petitioner while on interim bail. Matter will be stayed commencing from 21st July 2025. A copy टे दे दियो.
These application अच्छी कोटे suspension of मतलब stay of relation of fine and
सेटा अच्छा अच्छा ए week कर दियो से एटा होची आपनकर 115 टा होची bail आउटा कोन को 114 ना order किस पास है नहीं.
actually
114 order dispose of ये. Stay realization of fine order है ये already. 27/8/2024 रे है ना. Yes. अभी गुटा का सु 115 का सु.
He has a copy mirror.
Number पड़ी नहीं खाली copy.
So the cartesian system. Learned counsel for the state submit that he has received the copy of the interim application and seek some time to obtain instructions with respect to the conduct of the petitioner while on entry. Set up that is about to supply to them. Yes.
Item 20.
Mr. Sri Chandan. Okay, now. Okay,
In this case, my lord, notice was issued
wait.
to the victim. It was shot on 7/7/2025.
In which matter? This item 20?
20, my lord.
Yes, you got the report.
Yes.
The learning counsel for the state has produced the receipt notice documents relating to service of notice on the victim, which is taken on record. Stop.
It was shot on 7/7/2025.
The notice has been served on 7/7/2025 in order to give chance to the victim to engage her own counsel. The matter will be listed will commencing from 28th of July 2025. If any counsel enters appearance for the victim, the wakalatnama shall be placed on record and the name of the learned counsel be reflected in the cause list. ये सब मैटर अपन जेतोले नोटिस सर्व करछंती आउ गोटे ऐड करंतु ता देरे जे आपण जदी चाहिबे जो हाई कोर्ट लीगल सर्विसेज अथॉरिटी रु आपण को वकील दिया जीवो एमती किछि अछि नहीं किछि
ना ये सा फॉर्मेट रखन जो माने वर्क फोन पचार चन ताको कहि देउ
नहीं
Notice will contain.
ट्राइबल लोकोडा ना तो ताको आपण नोटिस टारले से नहीं धरि दे बस जियो चुपचाप तेणु उच्च न्यायालय को आसवाकू तार पैसा पत्र जो दरकार ताकू जदि आपण कहिबे जे फ्रीली तम केस लड़ी परिबो तमे ये सब जिंस जदि कहिबे ताहले सी होय तो राजी ही जाई पारे एवं वकालतनामा साइन करी आनी पठे दे पारंती तो इन द मीन टाइम यू टेक दिस इंस्ट्रक्शन है ना द लैंड काउंसिल फॉर द स्टेट शैल obtain instruction in the meantime whether the victim is intending to engage any counsel from the legal aid, Orissa High Court legal aid services. Yes, free copy of the order be handed over to the land counsel for this time.
Item 21.
Manner of prayer for bail and for interim health or medical grounds. IN number 73/2025. Offense committed under section 302-34 of IPC. Date of occurrence for RI 28/12/2013. My lord, more than 12 years. My lord, suffering for that is hereby submitted by the present petition that the wife of petitioner, namely Sunita Swain, is suffering from lymphatic leukemia and undergoing treatment.
रोगो नाटा कोन
Omina Swain.
हां रोगोर नाटा कोन
रोगना होची lymphatic leukemia.
से कौन से रोग गूगल में सर्च
कैंसर पेशेंट
देखिथिले से रोग कोन तार कोन हुए
Nikum.
ଆଗ୍ରହ ହେଲାନି ଗୋଟେ ରୋଗଟା ପାଇଁ ଆପଣ ଇଣ୍ଟରିମ୍ ବେଲ୍ ପକେଇଛନ୍ତି ଆପ୍ଲିକେସନ ସେ ରୋଗ ବିଷୟରେ ମୁଁ ଜାଣିବି କଣ ଟିକେ ଗୁଗୁଲରେ ଦେଖିଦିଏ
My lord, original certificate is
ତ ଆପଣ ପଚାରୁଛି କଣ ରୋଗଟା କଣ ଆପଣ ମନା
cancer
କରୁଛନ୍ତି
patient. Undergoing treatment from May 2024 under the
ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଲେ ମିଷ୍ଟର
my lord instruction ଯାଇଥିଲା.
ତାଙ୍କୁ ପଚାରୁଛୁ ଷ୍ଟେଟ କାଉନସିଲ
that is page my lord ଦେଇଛି ଖାଲି କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ପାଇଁ କୁହାଯାଇଥିଲା ପୂର୍ବରୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଟା ଫାଇଲ ହେଇଛି that suffer
Do you have the instruction regarding the interim
yes
application?
that is true my lord
about the health condition you see he is suffering from cancer
yes my lord
and he was under treatment since the wife under treatment since 2024 so first of all whether this treatment is correct or not and whether there is any other family members to take care of ଜଣେ ତାକୁ ଯଦି
ନାଇଁ ଦିଟା ଛୁଆ ଅଛନ୍ତି ଆଉ କେହି ନାହାନ୍ତି ଦିଟା କେବଳ ମାଇନର ଛୁଆ ଅଛନ୍ତି
You are opposing.
Same cause of action, same dispute.
ଏଟା ଏଇ ଯୋଉ ରିପୋର୍ଟଟା ଆସିଛି କିଏ ଦେଇଛନ୍ତି ରିପୋର୍ଟ ଏଇ ଯୋଉ କ୍ୟାନ୍ସର ଇଏଟା
Minor. 1-1. JCRL 1/11/2024. Amina Sai, wife of Hans.
Medicover Cancer Institute, Vizag, Rajwa. Have you obtained instruction about the authenticity of this document?
yes yes
କଣ ଆସିଲା
positive my lord is suffering and only 2 children
କେବେ ରିଜେକ୍ଟ ହେଇଥିଲା ମେରିଟରେ
3/12/2024. Marriage.
case of double murder eyewitness are there
the London Council for the state has IN number so and so this is an application for interim bail 73 on the ground that his wife who paragraph election wife of the petitioner is suffering from cancer and is undergoing treatment since paragraph 5 where lekha hai in support of such contention medical documents have been annexed to the interim application. Land Council for the state was asked to obtain instruction on this said application. Today, the Land Council for the state has produced the written instruction received from IIC Pattapur Police Station dated 9/6/25 to show that the wife of the petitioner is suffering from so it and as per the advice of the doctor, she needs under care to and she has got 2 minor children. 4 months now.
I'm in 95. Survival. So I did.
Yes. 95 ରେ ତ ବେଲ୍ ଆପ୍ଲିକେସନ ନାହିଁ
No, no, they should not waste time.
ଦେଲେ ଆସିଲେ ଆସିଲା ଦେଲେ ଆସିଲେ
My lord,
ତାପରେ ଆଉ କୋଉଥିରେ ଅଛି ବେଲ୍ ଆପ୍ଲିକେସନ
my lord, I am for the 124 and 137/24. I filed II for bail and fine that appellant custody more than 11 years. That maybe custody certificate may be fine.
You have not received or
no
received?
for the first time
अच्छा लेखन JCRL 100 of 2024 IN number so and so for stay of realization of fine that is allowed.
IN number 143.
Just a minute. Stay fine allowed. IN number 143 of 25 is an application for bail. Land Council for the petitioner submit that the petitioner is in judicial custody for more than 11 years. Stop. Land Council for the state has received the copy of the interim application.
No, interim application.
Submit that he has not received the copy of the interim application. Let the copy of the interim application be served on the Land Council for the state by tomorrow. And instruction be obtained relating to the criminal antecedent and also to produce the custody certificate. Put up this matter a week after as a similar order to be passed in the connected matter.
My lord, on a connected matter, what happened, my lord, that appellant is more than 70 years old and that disease specific cardiovascular disease. I searched and I found that it is a terminal illness disease. And another aspect is that NALSA report is forwarded by the DLSA Parampur to the Odisha State Legal Service Authority. I also visited there and I verified there. That report is lying.
Report of High Court Legal Affairs. No, this is a terminal illness. Second item, the 133 of 2024. Terminal illness. Yes. Now the age be 72 years. So both the conditions. So listen. IN number 141 of 2025. There is an application for bail filed by the petitioner. The Land Council for the petitioner submits that the petitioner is more than 70 years of age and she is suffering from terminal illness and is in judicial custody for
more than that one.
You are on bail. This man was
during trial. I am on bail.
Acha. And the petitioner was on bail during trial. And therefore the bail application may be favorably considered. The other report was by the order dated 26/2025, when the submission was made by the as for this one, so the report has been received from the medical officer circle jail Parampur that the petitioner other G-star 72 years suffering from Swansu and he was admitted in the Swansu, diagnosed as Swansu. Registered submission of report regarding age and terminal illness. And that illness is Swansu, the terminal illness. You can get it also if it page 72 brief 95 total page number 72 report. Swansu is released on bail, allowed.
142 fine.
Bail application allowed and sterilization I find.
Obliged.
Item 22.
Before I move with the apology for senior may advance. The last occasion, this criminal antecedent first certificate was called for. CA and C was called for.
Who three?
22. And your issued a paper only next week.
It was called for before the vacations.
Since 24th of April, your lordship has been passing successive orders. 24th of April.
The wrong file was provided instead of CRL 50 for CRL 50.
But that was provided, I know that was provided on Monday and that was rectified. As I know, the office is rectified by substituting the correct file.
Yes, yes, that's
We
right.
record the serious objection of Mr. Daur for adjournment, but all the same, we will grant you adjournment. Next week,
Next week.
Look from the
Monday.
Monday, Wednesday, Friday, जो दिन आले आसिबो सर वो दिन कौन आले
Monday.
The land council for the state submits that he is yet to receive the instruction. Bond bank criminal antecedent and present the petitioner and also to produce the custody certificate. 14 तारीख रखला होगा तो और फोन से टाइम
16th Millers, I will not be there. I am appearing in a connected matter.
18 तारीख आसु सम्मत से रहिबे 18
चौधरी आसु देखा कौन हो
6/20/25
मतलब let it come on 14th. That's what I see. 18th पुणी मते असुविधा कि से शिशुर असुविधा से एमती हेइकरी आ होबनी 14 तारिख में आसु त देखा 14 तारिख कौन असुविधा
नहीं मोहन काले न आसे पुणी आपण से दिन
अरे काले न आसीबोनी
April order which आपण आणूनते
put that section officer under suspension. एकदम सांग टाइम
Okay. 14, 6/20.
Yes, suggested we can.
Guys, my Lanan Sinaja I cannot reply to them.
All right.
Item 23.
This application. So far I am concerned, I stand in a different footing in advocate. I was in jail custody at the time of the occurrence. I have been implicated basing on a chance witness statement that I transpired. No evidence.
So many applications have
individually, all the.
So how many persons face trials? Mr. Chodangi?
Yes, ma'am.
Total number of accused persons during trial is
10 Millers.
10. 10 10 जन जब conviction है So what is the case? What happened?
It's a case of murder, Millers.
No, murder to money. I'm asking that when all these stalwarts are appearing, there must be something special in the case. So, कौन से गोटे मर्डर ना डबल मर्डर ना
गोटे मर्डर but the two groups in the bomb the two acting within the two groups and the bombing
political groups.
Nothing political. Allegation is he was having tea and a tea stall. He was having 13 antecedents. The deceased, something Prasad Biswal. Our allegation is some people came in motorcycle, hurled bombs, resulting in his death.
Antecedents also again.
Antecedents, we have filed compliance affidavit. So far I am concerned, I have acquitted from 3. One I.
You are not solved the
Still long, it's there on record.
file is capable. Copy देना है. Most copy देना.
ମୁଁ ଆଜି ଆଜ୍ଞା ଫାଇଲ କରୁଛି ମୁଁ ଆଜି ଫାଇଲ କରୁଛି
ମାନେ କଣ
କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ
ହଁ ସେ ତାଙ୍କର ମିଳିନି ତ ଟୋଟାଲ
ନାଇଁ ଦେ ଅଛି
କି ଆପଣ ମାନଙ୍କ ଭିତରେ ବୁଝାବୁଝି ହେବେ ନା ଆଉ ଆପଣ
no once we file it automatically it goes to them.
No so now the system is unless we serve a copy office never accepts any application from us.
This is one of your brother is making a statement, how can I dismiss?
No, don't say that.
We don't say
not
lying.
He can ask for copy, we can give him copy, but there is no doubt. But saying that it is not served with copy, I am saying. Unless we serve a copy, it will not be registered.
Just serve one.
Copy
Tell us one date next week so we can take off. Mr. Kanun go tell us one date. You have not received the copy of the comprehensive affidavit in any case.
The fact that you people are appearing, it indicates that you are not entitled to bail. It's very difficult case for me.
No. But out of 10, they have allegation against 4 are not.
There is nothing.
I was in jail custody when the occurrence took place.
No, the London Council.
So hardly there is an evidence.
Still there is a conviction. He has not received the copy of the comprehensive affidavit, which was filed by the Land and Council for the appellant. Let the Land and Council for the appellant serve copy of the comprehensive affidavit from the Land Council for the case by tomorrow. By tomorrow. This matter. Upon proper instruction नहीं जाऊँ तो बुधवार दिन नहीं आशु.
No, 16th I will not be available.
अच्छा, तो 18 तारीख में नहीं आशु. 18.
काली की फाइल करके काली की कॉपी देवी
हाँ
मो पाखरे रखी दो
आपण देई दियंतु तां कॉपी देई दियंतु 18 तारीख रे आसीबो 18/7/2025 रे एटा गोटी ऑर्डर करिवे एवं दैट इज टू कम अलोंग विथ ऑल दिस क्रिमिनल अपील्स.
With the permission, my lord, so for my criminal appeal of this concern, my lord, copy already given and received by file.
बुथरे आमे कोन इटा इंडिविजुअली ऑर्डर करू जोथरे देई नांदी से कहउजंदी देई देबे ओटा कॉपीटा कोन आधे रसु
आगे दे देबा with the permission कोर्ट खाली दे पारिबे कि ऑनरेबल कोर्ट my lord
कोनटा
antecedent
आपण फाइल करना तांको खाली देले कोन हो
कॉपी दे दे तांको with
कोर्ट रे फाइल करना जी तांको खाली कॉपीटा देले कोन हो
ना तांको दे दे
अरे बाबा कोर्ट रे फाइल करिवे ना नहीं
आगे
फाइल कर नांती
with the
परमिशन कोन दरकार है.
My lord, may I pray that your lordship serve a copy of the format.
That copy of the comprehensive affidavit shall also be served on the Land and Council for the inquiry.
Okay.
Yes.
More criminal appeal 356.
We are actually, why are you speaking? Let them file it on the counter.
Counter file कर दो.
Why don't you file it in the counter?
आगे रेकॉर्ड टाइट अछि काउंटर पहले आपन कते आसीबो
आसीबोनी के सब मैटर आछी आसीबोनी
मैं काउंटर पे
काउंटर फाइल कर
काउंटर फाइल पे स्लिप अलमेंट देगा. Yes, next.
Item 24.
24, Mr. Ghadi.
I prefer next week, my lord. So for my matter is concerned, I prefer next week.
हाँ आपण अछंती बाहन पे
My lord.
Mr. Mahapatra, you are there in number 2. And number 3 रे की अछि.
Before commencing, I have a small request. Because I have a meeting at Bhubaneswar.
Tomorrow.
I want to leave the court because it is. So I request my friends, because others are there. I'm sorry for inconvenience.
No, it will
but
be taken
it may
up.
be taken up next
Next week. Mr. Ghadi, next week.
On 11th.
Next week. 16 तारीख रे रखले किछ असुविधा अछि कि?
हाँ, sure.
16 16/7/2000.
दादा इंस्ट्रक्शन दिला आसिया को प्रथम
आनिचंदी आपण सीए आउट कस्टडी सर्टिफिकेट
Custody certificate and CA.
खाली कस्टडी सर्टिफिकेट आनिचंदी
CA yourself.
सीए आनिचंदी लिखंतु फास्टर लिखि देबे द लैंड एंड काउंसिल फॉर द स्टेट सबमिट्स फाइल द instruction relating to the criminal antecedent. However, seek some more time to produce the custody certificate. Is this matter? Okay, 16/2025 ହେଲା ए गोटे के फास्ट ହେଇଥିଲା ସେଇ ଟାଇप ର order.
Each case, I am appearing on behalf of the informant. Each cases, your lordship directed for.
सब केस रे कोइतला आपण गोटे केस रे देले केमदी हो तांको पई कोन पुनी 8 जन हो ना.
Many cases are there against each and each.
No, we are not on that.
Madam.
We are on that ए जो आपण को जो थरे मिस्टर महापात्र appear करजंती, मिस्टर दास appear करजंती तादेरे मध्य कस्टडी सर्टिफिकेट आ क्रिमिनल एंटीसीडेंट
सर्टिफिकेट दरकार नहीं केवल खाली एंटीसीडेंट दरकार
एंटीसीडेंट एंटीसीडेंट अछि तो सब फाइल कर देन बड़ा फाइल कर देन
हां समस्त बोलो एंटीसीडेंट
यो 2020 ऑल नेक्स्ट
Item 25.
May please, my lord.
Only my name may can be reflected.
हां आपण को बोले जो डेली बेसिस रे बोले I'm Mr. ଆପଣ କ୍ଲାଏଣ୍ଟ ଦେଖୁଥିବ ଲାଇଭ ଷ୍ଟ୍ରିମ୍
Because we are both brothers, we are fighting in informant side.
ଆପଣ କ୍ଲାଏଣ୍ଟ ଦେଖୁଥିବ ଲାଇଭ ଷ୍ଟ୍ରିମିଂ କରିକିନି ଆପଣ ଏମିତି ଗୋଟେ
I cannot say anything.
Item 25.
May it please my lord, in this case, I am for the appellant Butujana. Petitioner has been convicted for life conviction. I am for the bail. In this case, I am in custody for more than 9 years, my lord. And so far the case is concerned, it is based upon circumstantial evidences. And
report has come.
Yes, my
custody certificate କେତେ
Yes.
ବର୍ଷ
3,369 days.
କେତେ ହରଲେ କେତେ ହଉଛି
9 years, 2 months.
Okay, so is it a case based on circumstances?
My lord.
Yes, my lord.
What are the circumstances?
that is running page 33, the confessional statement given by the co-accused person. Subsequently, I have also given confessed before the police, and that is leading to discovery. Some articles which has been found from open spaces. In that there is a chart something. So far, my case is concerned.
Leading to discovery of some articles
My lord.
which you are lying in the open space.
My lord.
That is the only evidence against Butujana.
My humble submission is that, my lord. That is, the accused Butujana led the witnesses to police. That is running page 56. The accused Butujana led to the witnesses and police team to the place of concealment articles of the deceased persons and gave recovery of ornaments and yellow color banyan.
No, you come to paragraph number 14 of the judgment.
My lord, that is
circumstances.
my
have been
lord, the
justified.
confessional statements given by the accused person soon after the
This you do not dispute that this is there.
my lord.
Theory of leading to discovery, that is also there.
My lord.
Crime proceeds and duties. ये जो कौन आपन को instance से बाहर ची?
That is
Ornaments.
50, 56 रो अच्छी running page 56 para 2. The accused Butujana led to, before that thereafter they returned to the police station and came to know that police have apprehended other 2 accused persons, namely Butujana and Vijay Kumar Jadhav. In the similar way, both the accused Butujana and Vijay Kumar Jadhav gave their
It's a case of double murder.
my lord, confessional statements under section 27 of the Evidence Act, which were recorded by the police in presence of the witnesses. The accused Butujana led to the witnesses and police team to the place of concealment of articles of the deceased persons and gave recovery of ornaments and yellow color banyan, which were seized by the police in
These
presence.
ornaments has been identified to be that of the deceased. ଆପଣଙ୍କର deceased ornaments ଚୋରି କରିକିନି ନେଇଥିଲେ ତାକୁ murder କରି ପରା
Concrete evidence କିଛି ନାହିଁ ଯେ I was present there. Motive ତ ଏକ
let us say that some ornaments were seized at your instance,
my lord.
but the prosecution has to link those ornaments with the deceased person.
My lord.
So that will create a otherwise merely recovery of some ornaments at your instance, that will not do. So it is a case of robbery of articles from the deceased persons and it was recovered at your instance. So we are posing you a question that whether the ornaments which were recovered at your instance been proved to be that of the deceased or has got any link with the deceased. Na taku dekhi na Mr.
My lord. Leading to discovery, the present petitioner led the police to his cabin. Under the earth, he concealed the ornament, my lord. That ornament was put to PI period and PW2 identified the ornament, my lord. PW2 is the daughter of the deceased person. He identified the ornament that belongs to her mother. That apart, my lord, the present petitioner also gave discovery of his shirt. From where the blood stain was detected, that was marked as L. And from that shirt, a C report, human blood of B grouping, which belongs to the mother of deceased. Was also.
These are the circumstances.
So how do you say that there is nothing, because if the deceased ornaments were recovered at your instance from
hidden place,
in a hidden condition, from below the cabin as stated by the witnesses. So what is your explanation in the accused statement?
Cabin also access to everybody else, that not from inside the cabin. But
under the
cabin ତଳେ ମାଟି ଭିତରେ ପୋତା ହେଇଥିଲା ଯୋଉ ସୁନା ଅଳଙ୍କାର ଗୁଡାକ ସେଗୁଡାକ recovery ହେଲା ପରେ that has been put to TI parade and the daughter of the deceased has identified the same.
They are not gold ornaments.
that has been identified.
They are all imitation ornaments.
Yes, imitation, but that belongs to the mother of the PW2 and it was identified by PW2 in the TI parades.
Okay. Is there any other material? Last scene?
No, ma'am.
Motive is that commission of
the
that robbery.
So for motive part is concerned, motive has not been proved.
No, motive is that robbery is the motive. Because even if it is let us say it was not imitation thing that the accused persons might not be aware that it is an imitation one, but they might be thinking that it is a gold ornament. So that is not the thing, but what about the criminal antecedents?
No criminal antecedent.
And all detailed reports is another material there.
Against another accused.
Not even. କେତେ ବର୍ଷ ରହିଛନ୍ତି ଆପଣ?
9 years custody.
Custody certificate.
9 years, 2 months, whatever my lord and
କଣ ହେଲା?
2 months. My lord, 2 senior citizens. Alone. They were staying alone. And some of the accused persons, they were trying to take on rent that house. By that process, they closed my lord. Against the present petitioner, this is the material leading to discovery.
No, we are considering the bail application of one.
Yes.
We are not considering the other. Each bail application will be considered on its own merit. Now he says that so far as his accused is concerned, no criminal antecedent, custody for more than 9 years, only material is the leading to discovery of the ornaments which were identified in the TI parade and recovery of his banyan, which was found to be stained with blood and it
blood
matches with the deceased blood.
Yes.
That is all, and in the accused statement, he has not offered any explanation.
Yes.
That is it the case?
Yes, my lord.
We'll consider about the other cases, we'll consider. It's not that.
Have you offered any explanation? 330? No.
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 It's equal to 9 months. What is the avocation of the video? He was having a cabin or
Cabin, retail shop, where all the accused persons were congregating.
He is a local resident or outsider? This
He's a-
Guttu Jana?
I am from Jagatsinghpur.
Jagatsinghpur, and he has a cabinet near Maharaj Takish Bhubaneswar.
No, it's 46.
On the first item, Buttu Jana, CRLN number 251 of Swanson. First, to IN number Swanson, there is an application for stay of realization of fund that is allowed. Second, IN number 568 of 2025. There is an application for bail. Land counsel for the petitioner submits that the petitioner is in judicial custody for more than 9 years and the case is based on circumstantial evidence. And the petitioner has got no criminal antecedent. The circumstance available against the petitioner is that at his instance, some ornaments were recovered, which were letter placed in the test identification parade and identified by PW2 to be that of the deceased, and recovery of one sart accounts
Banyan. Yellow color banyan.
Yellow color banyan, which was stained with blood, and on chemical examination, the blood proof matches with that of the deceased. Land Council submits that the petitioner is a permanent resident of district Jagatsinghpur and is was running a shop in Sukhbihar Basti. The shop and therefore, and there is no chance of early hearing of this appeal in the near future. Therefore, the bail application may be favorably considered. Land Council for the state has not disputed about the period of detention of the petitioner in judicial custody for more than 9 years, and also that the petitioner is having no criminal antecedent. Considering the submission made by the Land Council for the respective parties and in view of the available material on record, since it's a case of double murder, the conduct of the petitioner, if he's released on interim bail, we think it proper to grant interim bail for a period of 3 months to the petitioner. Matter we listed on such and such date, the Land Council for the petitioner shall file the surrender certificate, and Land Council for the state shall obtain instruction regarding the conduct of the petitioner while on interim bail. This rest of the matter we take up on Friday.
With matter, one thing, my lords.
There are 2 other available.
This item in the connected matter.
Friday, Mr. Panda, it will come.
My
on
lord, I
Friday.
am only praying that let the state get instructions as to whether during bail period, my lords, the appellant in my case, what is the report against him?
It is number 2 related to CRL number 385 of 25. Mr. Devasis Panda, Land Council for the appellant submits that the petitioner was on bail during trial, and he has instruction that the petitioner has not misutilized his liberty in any manner. Let the Land Council for the state obtain instruction in that respect. So it obviously cannot come on, it will come on next week on 18th it will come.
In my case also same mail order pass.
Apna bail lethile?
Bail lethile.
Same 18/7/2025. अब बाकी जो भी बुक मैटर्स तो प्रोवाइड नहीं है।